That's why he's so desperate right now.
75 years, something crazy. I don't.
Oh,
Okay. I do these things. One of them, Mr. Reeves, he's in trouble with
Praise the Lord! Exclamation mark. David's MRI came back clean. Well, they were afraid it's cancer.
You solemnly swear to affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Grab your paperwork and step over there. Keep your mask up. Once it goes up, put your chest. You have a signature
Estás
over
por
there.
acá y sin hacer. Insert. Got it. There we go.
All right, Mr. Salazar, you have filed the motion
No,
to
para
require,
pedir que
where is the motion? Asking that Mr. Rush be removed as your attorney of record. First of all, is that correct?
¿Eso es correcto? Usted hizo una petición para que saquen al señor Ross.
Yes.
Yes.
Explain to me why.
Dígame por qué.
En primer lugar, porque pues los hechos de representación no los he visto completamente.
First of all, because the facts of the representation, I haven't seen anything correctly.
Que de la última vez que estuvimos aquí en la última reunión, el 7/9 de 2020,
The last time we were here on the last court on 7/9 of 2020,
supuestamente iban a quitar el segundo cargo,
supposedly they were gonna remove the second charge,
pero no he visto ninguna diferencia en la sentencia.
but I haven't seen any difference on the sentencing.
Sigo apelando los 40 años que tengo, pues no tengo ningún remedio.
I am still appealing the 40 years that I have, and I don't have any remedy.
No me dio ningún remedio,
He hasn't given me
Para
any
mí.
remedy.
para mí no tiene, no me ha estado representando.
So in my opinion, he has not been representing me.
Did he discuss with you
Él
the fact that the
El hecho de que
second degree murder
el
sentence
cargo de
is a separate and distinct sentence from your attempted aggravated rape?
Distinta del intento de violación.
Es una, si esto desde el 2006 que me di culpable, supuestamente estaba corriendo
If,
junto.
if supposedly since 2006 that I pled guilty, supposedly they were both concurrent.
Entonces, si me quitan un cargo, no me pueden condenar a una felonía de asesinato, quitando el otro cargo.
So if they took one charge away, they can sentence me to a felony of a murder case on the other case.
El único remedio que yo le pedía al abogado que pidiera que me rebajaran mi sentencia de los 12 años que tengo, que los 12 años que del segundo cargo, que me los quitaran de los 40, entonces ya no podía.
So the only remedy or the only solution I asked my attorney to get for me was for them to take the 12 years from the second charge and take them off the 40 years.
Así nos ahorrábamos mucho tiempo y dinero en de que me dieran una oportunidad de que me quitaran el cargo segundo, pero también que me quitaran los 12 años junto con el cargo.
So that way we were saving a lot of time and money, and if they would take the 12 years from the first charge, but also 12 years out of the second charge.
Did he explain to you that they are separate and distinct
Son
sentences,
dos sentencias separadas y distintas.
and that one
Que una
the fact that they're concurrent doesn't mean that
Son concurrentes, que son al mismo tiempo.
the 40 years would have to be reduced by 12 years
Los 40 años tienen que ser reducidos
if the attempted rape, aggravated rape was
El
dismissed.
caso de violación agravada fue desestimado. ¿Me explicó eso?
Sí, pero todavía sigue en mi récord. No,
Yes,
no,
but
no
that's
me lo
still
han
on my
quitado.
record, they haven't taken it away.
But did he tell you under the law he didn't think they could take it away?
Porque bajo, él te explicó que bajo
Or
la
we're getting off base of
él no cree que puede
issue.
ser sacado.
Your Honor, just to clarify, the state had been willing to make that agreement with Mr. Salazar. However, Mr. Salazar was unwilling to accept that agreement he still was in the position that if any part of the plea was involuntary, the entire plea was invalid. So that was what we ultimately litigated last summer.
So what the dispute, the way he just explained it was, is that the dismissal of the aggravated attempted rape should reduce the 40-year sentence to 28 years.
To be honest, that's the first time I've heard that.
Okay, so that's part of my concern, that he doesn't really understand what he's asking for. I think the argument may be stronger the other way than it is this way, but.
Well, the other argument I researched and he has researched, we just disagree on the point that if, as the court says, you have separate counts and separate convictions, an invalid count doesn't invalidate both counts. And he's of the position that it does. I was unaware he thought that it would be reduced by 12 years. And the reason that it still is on his record, as he says, is because we did not accept the state's offer to do that.
So if I understand it, you and Mr. Russ just absolutely cannot agree on the legal aspects of your sentence.
No,
No,
no estamos de acuerdo porque
Why do you desire to proceed on your own rather than a substitute attorney?
Porque si no me recuerdo, la última vez que me pusieron al señor Ross, me dijeron que él era el último abogado que yo podía tener.
Because if I remember correctly, the last time when they appointed Attorney Russ to me, I was told that that was the last attorney that I could have.
So
Entonces,
are you interested in representing yourself, or are you asking the court to substitute counsel?
yo me represento yo mismo si no tengo otra opción.
I would represent myself only if I didn't have another choice.
If I gave you another choice, would you prefer having an attorney, or would you prefer representing yourself?
Si me da la oportunidad, yo preferiría tener otro abogado.
If you would give me the opportunity, I would prefer having another attorney.
I mean, I think that's a better choice, and it kind of eliminates the need for the second.
Yes, Your Honor, I would agree. Again, I.
Do you, both of you come here for a second.
He doesn't know, I'm just saying, if you get the ruling where the leaks out as to who it is, you'll do that for me. Just think about it, okay?
Mr. Salazar, what I'm gonna do is, I'm gonna remove Mr. Russ from as attorney of record. I am going to give some thought as to who I'm going to appoint to represent you on the issues that you're concerned about. Okay? I will issue an order this week identifying who that attorney is and making sure that they have your contact information, which I assume, Mr. Rush, you have all that information.
Yes, Your Honor, I do.
And we'll go, and he will get Mr. Russ's file, and we'll try and get this back on track with the court of criminal appeal.
Línea con la Corte de Apelaciones Criminales.
Quiero decir algo.
I want
to say something?
Ahora,
Sure.
yo no quiero mucho, ¿cómo se dice? Dar mucha modestia, solo quiero que me rebajen un poco de mi sentencia, que no me siento
I just,
contento con mi sentencia, que me den una oportunidad.
I am not trying to be difficult and I don't want to be a bother to everybody. I just want them to give me an opportunity and to reduce my sentence a little.
I understand and respect that, that's certainly within your right to try and do that. Sometimes the attorney and the client cannot come to an agreement on what the law says. But I will try and get you someone else that will work with you and try and help you get to where you want to get to.
Porque digo, yo no pido que me dejen en libertad hoy mismo, sino solo eso es lo que pido, que me aligeren mi cara.
Because I'm not asking to be put out of jail today. I'm just asking for my charges or my sentence to be reduced.
Well,
Okay.
I respect that and thank you for that. I'm trying to appoint an attorney who can do what they can to get that.
Gracias.
Anything
Thank you,
else?
sir. Thank you very much, sir.
All right, thank you.
Gracias a usted.
Thank you. Appreciate it, Mr. Rush.
No problem.
Thank you for coming over, Ms. Lee. No, we were. Motions, but only one of them, he made moves on. So, Mr. Kenny?
Judge, yesterday, Carl Kinzer was on the docket.
Excuse me just a second. Just make sure everybody. Yeah, wait. All right, Mr. McKinney.
He had his dates confused.
Who?
Carl Kinzer, he was on yesterday's docket. And he's here on the front row, Judge. He's got his IOP scheduled this Thursday at 1 o'clock.
This is what Mr. Gailey came yesterday about, he was not calling.
He's not doing much of anything right now, and we want to know why.
Well,
The LP is one thing, but he's not maintaining contact, he's not otherwise doing what he's supposed to be doing. If he's not gonna do those, then I might as well put him in custody so we can go ahead and have a quick hearing.
well, Judge, what I would suggest we do is we give him enough rope to either free himself or enough rope to hang himself. And we put it after about 3 weeks after today and see how he's communicated with her and whether he's gone to the
When does he
IOP.
go into IOP?
Pardon me, he's supposed to have his first assessment at 1 o'clock on Thursday.
I thought he had already been approved for
He
IOP.
had COVID and broke his ribs.
That's because he's out trying to buy boats.
I understand, Judge. I'm just the messenger, Judge.
I understand that, but I really don't have much sympathy for a person who breaks their foot and their ribs because they can't walk the pier as they're looking by the boat of their dreams.
Well, Judge, sometimes as we age, we have to chase nirvana. And maybe that's it for him.
He needs to be chasing freedom
I understand
because
that.
he's about to lose all of that. That boat won't do him a bit of good at the penitentiary.
I understand. And I think he understands the situation now too.
If there is one, when's the assessment?
Thursday at 1 o'clock.
He can be back
Oh,
next
at
Wednesday.
10, I'm sorry, I got that wrong.
Thursday at 10, I got to assess.
He can be back next Wednesday with exactly a plan of when he's going in, and he better be, in the meantime, he better be doing everything else he's required to do, and that's second contact.
Judge, I'm not gonna be here next Wednesday. If we
I
could
don't
do,
care, because there's one of two things gonna happen. He's either done everything he's supposed to do, and we'll leave him alone for a month, or he's going into jail because he didn't do what I just told him to do.
okay,
There
Judge.
are no in betweens.
Just for the record, next Wednesday,
He either has
At 9 o'clock.
assessment done and his date to enter into it ready for the court. He has proven that he's been in contact with the veteran court representatives and that he's doing whatever else they tell him to do. We'll have her up here, and if she says, yeah, he's done it, then he walks out. If he says, no, he hasn't done it, then he walks in.
Okay.
He's going one of two directions based on him taking care of his responsibilities.
I'll
I
have it
don't
come to
care
Jesus.
about his COVID, I don't care about his broken foot, his cracked ribs, I don't care about any of that. I care about him showing responsibility to the court for the egregious wrongs that he has committed.
Yes, Your Honor, we appreciate your gratitude.
Thank you.
Where's Mark Pickle? I just saw him walk outside
So,
down the
Mr.
hall.
Thompson, where is he?
He just asked for 2 weeks. He's been out for a year and he's gonna get with Koya. And, we put it on 5/20.
Correct. There's it.
Yeah, go to work. But we can do, Miss Smith is still not here.
Mr. What was the day on Friday?
Here's Mr. Peckham coming in the door.
Vince, the guy from Kroger. I've got his number. I told him that she is not here, she has an outstanding warrant. I would contact him, so he logged off.
Okay, perfect, thank you.
We have, did, Ms. Smith, Tiffany Smith ever show?
No, sir.
Or vacation is open for?
Okay. And if we go to Mr. Mitchell.
Is it ready to be done real quick?
We're ready, Your Honor.
Pardon?
We're
Ready.
ready.
Okay. Is there an officer on this? Yes, sir.
Yeah, he's
I
ready.
have to try and get somebody out of here.
Officer, someone from our place.
You need Erica?
You need to put that in for me? A lot of things, I don't think he's gonna do. Pain medication.
Do you have Erica Peters' number?
I do you need to, can she zoom in?
That's fine.
Okay, I'll send it to her.
And also, did the court receive a resentencing report yet?
Oh,
Well, that would,
Mitchell?
Hannah, do you know anything?
I do not know. I can check.
Okay, will you please check on that on Ronald Mitchell?
Could she be a-
Okay. Even if the court has not received the resentencing report, I'd like to go ahead with the 3 witnesses we have today, and then if we could potentially address that issue at the end.
All right.
Your Honor, I don't recall from the last time we were in court, was that report requested?
Yes, it was. That's why we continued it, wasn't it? Or one of the reasons.
It was well, it wasn't the reason we continued it, but I did ask for a resentencing report. It was the lady with the red hair,
Ms. Peters?
Ms. Peters, and she said she'd try and get it.
Yeah, and I think she said it might be too short a time, and I indicated, well, we had a re-sentence report just done less than 2 years ago, so it shouldn't be that much to update that. So, yeah, I mean, it was discussed at the last proceeding. So we'll go with the 3 witnesses you got at the moment.
Don Kennedy.
Yeah. Is that the?
You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay. Will you please state and spell your name for the record?
Dawn Kennedy, DAWNCANADY.
And are you familiar with the defendant in this matter, Mr. Ronald Mitchell?
I am.
And how is it that you know him?
We were in a relationship for 3 years, and yeah.
When was that you were in a relationship? What years?
It started in 2000 and the end of 2000, I want to say 14. It was 2014 to 2017.
Okay. And do you have children, Miss Kennedy?
I do.
And do you have a daughter specifically?
Yes.
What is her name?
Kamari Kennedy.
And how old is she?
She's 11 now.
Did she have a relationship with Mr. Mitchell?
She did. She looked at him as her father.
Okay. And do you see Mr. Mitchell in the courtroom today? And if so, can you point him out and identify what he's wearing?
He's right there in the orange and white.
Your Honor, may the record reflect the witnesses identified the defendant.
Certainly.
I want to call your attention to an incident that happened back in April of 2020. How old would your daughter have been at that time?
She would have been 10.
Okay. And did you become aware around that time that something had happened between her and Mr. Mitchell?
I did.
And can you tell the court how it was that you became aware of that particular incident?
I was talking to my daughter one morning because she was asleep in my bed, or she was asleep in my room. And when I woke up, she was making, in her sleep, she was making like a kissy face, like as if she was kissing someone. And she was laying next to her stepbrother and sister. And so I woke her up and I took her into her room and I said, Mara, come talk to me. I said, what was you just dreaming about? And she was like, nothing. What do you mean? I said, what's going on? Because I had noticed a change in her behavior. She was walking around, like walking weird and, kind of just to herself, very, just not her normal self. And so I sat in the room, I talked to her, I said, has anything happened? Is everything okay? Like, what's going on? She's like, I'm fine. Before this, on her birthday, 2020, which was April 28th, I allowed her to spend the night with Ronald. When I picked her up the next day, I always ask, it's my daughter, so I always ask, anybody touch you inappropriately? Anybody do? No. It was a no from that. On this particular morning, which was about a month and a week later, she started just crying. And I said, Mari, what's wrong? And she was just like, I don't want you to be mad. And I said, what would I be mad at? I said, I promise if you tell me the truth, Mommy's not gonna be mad, it's okay. Did something happen? And she was just like, I don't want Kid to go to jail. And that's what she calls him. She calls him Kid. And I said, well, why would Kid go to jail? Like, what does it have to do with Kid? And she just started crying. Crying. So I grabbed her to me and I set her on my lap and I said, Mari, you and Mommy, I can protect you. It's okay. Like, just talk to me. What's going on? And she proceeded to tell me.
I'm going to object to hearsay evidence. The gentleman has the right to confront the accuser, even in this case, obviously, if the alleged victim's a child, but still, I would object to introduction of hearsay evidence.
And Your Honor, this is a community corrections violation. Reliable hearsay is admissible during this type of hearing.
Yes, I'm gonna overrule it. Sounds like maybe even though there's some questioning going on, possible excited utterance, because she's starting to cry and getting emotional. And so I'll overrule.
Okay, go on.
So she proceeded to tell me that Ronald touched her. I said, what do you mean when you say touched you, Mari? She said, well, he hit me. I said, he hit you where? She said, he hit me on my arm. I said, well, what did he hit you on your arm for, Maury? Because, and I said, because what? I said, now are you telling mommy the truth? Because you can be honest with mommy. She said, no. I said, okay, well, be honest, it's okay. What happened? He touched my leg. So at that point, I seen that she was trying to build up or build the courage to tell me that what had happened. So when she finally said he touched my private area, I asked her to show me. I said, how did he touch you? And she used her hand and she grabbed her vagina and she was like moving it, like back and forth. I said, did that hurt? She said, I don't know. I said, well, how did it make you feel? And she just started crying. I don't want him to go to jail. I don't want him to go to jail. Now this is my 10-year-old telling me that somebody has touched her inappropriately, but she wants to protect him still because she don't want him to go to jail because of how she looks at him and the love that she has for him. And
Okay, let me stop you right there, okay?
Mhm.
After she kind of disclosed to you what had occurred, what did you do next?
I wrote down what she told me, just to have an entry. I called my aunt and I explained to her what happened after I had to gather myself because, of course, I had to be strong in this case for her. But then I went to Antioch and I called the police because I didn't want them to come, with her around. I didn't want her to get nervous. I still had to go back to Murfreesboro to pick her up, but I filed a report because not one time did I ever think that what she was telling me was a lie. It's been a lot of incidents in the past years. When she was younger, she would sit on her bed and she would just sit there and cry. And I'd be like, what's wrong? What's the matter? I don't want Kid to go to jail. Me not thinking in my head ever once that this had occurred, but because he was in and out of jail, she just missed him. So I'm thinking but when she told me that he basically told her that this was something that could not get out because he would get locked up, it all started making sense to me.
Okay, so after you reported this to the police, did you speak with Detective Martin?
Yes.
Okay, and did you cooperate in the investigation?
I did.
And did you take your daughter to get an examination with the Our Kids clinic?
Yes.
And did you also take your daughter to participate in a forensic interview?
Yes, ma'am.
The night of April 28th, when this occurred, was it Mr. Mitchell's house she was staying at or someone else's house?
He was staying there as well, but it was someone else's.
Do you know that person's name?
Her name is Brandy.
Okay, and do you know Brandy? Like, is Brandy an acquaintance of yours as well?
No, ma'am. I'm not personally familiar with her. I met her.
But you met her?
Mm-hmm.
When did you meet her?
I met her, I want to say that day, I believe.
Okay, and would she have been at the house also?
She was gone.
She was going or gone?
No, she was gone. She wasn't at the house the night that we came back. I want to say she left because her daughter and his daughter was there as well.
Okay.
And that's why I allowed my daughter to stay the night.
At some point, did you were you asked to turn over your daughter's underwear that she was wearing that night to police?
Yes, ma'am.
And tell the court about that situation. How were you asked and why were you asked to do that?
Well, about a year before 2020, it was in 2019, I had got a message from the mother of his child, of his eldest child. She sent me a picture of her daughter's underwear and her daughter was 3 years old at this time. it had blood residue in her underwear. And from that point, you know, I asked her, when all this went on, I asked her, did anything ever come? Did come up, you know, you filing charges? Or she said she took her daughter to the hospital and they didn't find anything. They just think that it was an irritation. But me remembering that, I went back to the pictures from the day of 2020, April 28th, and I looked at her jeans. And I went in her dirty clothes and found her jeans just to see if there was any kind of residue. And I compared her underwear from before then and after then, and these particular underwear had a nice amount. It was a nice amount of a dark color substance, red, brownish. And so I said, I told the detective, I said, I even have her underwears from that night that I could give you. Okay. And he said, if that would be awesome if you can bring those into me.
And did you take them to him?
I did, yes, ma'am.
Okay. Did you ever personally confront or ask Mr. Mitchell about these allegations?
Never. He did text me afterwards, though.
Okay.
After he got a letter from I want to say child services, stating that he was going to be in this type of situation, that I filed a report. And he messaged me, and I never texted him back.
And what did he say in the message?
He just said, really, you know this is bogus for you to say that. I know Maria never say nothing like that. And you better answer me or I'll be at your auntie house.
Okay. And what did you take that to mean?
Honestly, I mean, I didn't really take it as a threat. I felt more so like you was trying to talk to me, but at that point I didn't have anything to say. Because my daughter has no reason to lie for someone that she loves so much, you know.
One moment, Your Honor. Were you aware that Mr. Mitchell was on community corrections supervision for a completely unrelated sentence during this time?
Yes.
Okay.
I don't know if it was the same situation, but I was aware that he was on probation.
I believe those are my questions. Thank you. The defense attorney is going to ask you a few, okay?
Thank you.
Ma'am, it's believed that this occurred on 28 April 2020, correct?
Correct.
And we know that specific day because that was the day of a birthday party in which your daughter stayed over at Ms. Brandy Roberts' home, correct?
Well, it wasn't a birthday party, but it was her birthday.
But there were countless other opportunities that Mr. Mitchell had contact with your daughter, appropriate contact. Is that correct?
Correct.
And so he's known you for a period of several years, going back as early as 2014. And by your own testimony, your daughter thinks of him as a father figure.
Right.
And yet,
you've at no time in all those years other than this have suspected had any concerns, have you?
I have not.
Have you had any ongoing relationship with Mr. Mitchell since the incident was revealed to you by your child?
No.
Okay. And what about at your residence? Do you currently have a boyfriend that lives with you, or other men that might have contact with her on a regular basis?
I do not. I'm actually single right now.
For the night of April 28th, do you know how many folks would have been in the residence, in Ms. Roberts' residence?
It was just me, Ronald, his daughter Layla, Brandy's daughter, and Mari, Kamari.
Did you stay at the residence the entire night?
I did not. It took me a long time to leave because I did not want to leave my daughter there. And she was begging to stay, but I was there for about a good 2.5, 3 hours before I actually left. And was like, because I planned on staying. I had planned on staying, but I had work in the morning and I didn't have any work clothes. But I was like, okay, my daughter has a phone. So, I said, I'll just call, make sure everything's okay.
Well, what time did you depart?
I can't remember the exact time, but it was probably about 11-ish, maybe 12. It may have been earlier, but it was later that night because we had went to the park and ate juicy seafood, and then we came back to his house.
And what time did you come back in the morning?
I came back after I got off work at 3:30. I worked at Vanderbilt at the time.
Okay, so you left around approximately 11 p.m. and came back to pick her up the next day after about 3 p.m.?
Correct.
Okay. And so you believe that this incident occurred during that time period, is that correct?
I do. I believe it occurred a lot more than just this time period as well.
Okay. If you give me one moment, Your Honor. So just to clarify, have you had any male friends that have resided with you since April of 2020?
Yes. I have, yes.
So there have been other men that have lived at your residence and have had access to the child?
Correct.
All right, I have no further questions, Your Honor.
When did this significant other live with you?
2018 to 2020.
When did that significant other leave in 2020?
September. No, August, because I moved into another place. And I also was roommating with my cousin at the time, so she was in the house as well with her 3 daughters.
What was your relationship with Mr. Mitchell after you
quit being in a relationship with him? What, describe did you continue to see him and talk to him and stuff?
We were still, yes, we were still cordial. You know, like I said, my daughter looked at him as a father, like she called him daddy. So it'd be a lot of times where she would want to see him. I kind of cut that off when he got locked up for some drug charges a couple years back. But I did allow him to see her because she kept asking about him. So I said, that's fine, you know, I allowed her to see him. Like I said, from the ages, she was about 4. And thinking about it, it actually goes back to when he dated one of my friends named Fantasia. We wasn't in a relationship then, but I've known him since then. And he's known my daughter, and she was like 2 years old at that time. But he never was around her, you know, for an extensive amount of time without me. But we were still cordial. I just know that the bond that I've built with my daughter from the time that she hasn't been around him to up to the time where she told me what happened, it was a stronger bond. Because I was working 2 jobs, I was going to school, he would have her a lot of the time. So he would babysit for me. So with it just being me now and me talking to her more and, you know, opening up that line of communication, she tried to keep it from me, but I told her she wasn't gonna get in trouble if she told me.
All right. Any other questions?
Hang on.
Thank you. All right.
I'll call Hannah Smith.
Now, if you would raise your hand, if you sworn, please.
You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Would you understand what step 1 for?
Will you please state your name for the record?
Hannah Smith,
And how are you employed?
with Davidson County Community Corrections.
And back in March, I guess, on or about March 24th of 2021, did you take out a community corrections violation warrant for Ronald Mitchell?
Yes, I did.
And what was the basis of that warrant?
So he was charged with aggravated sexual battery of a minor.
Okay, was there anything else alleged in the warrant?
No, that was the only one.
Okay.
For this one.
At some point, an amended affidavit for violation was taken out. Do you have a copy of that in front of you?
Yes, that was the amended. I amended the warrant for that new violation.
Okay.
The aggravated sexual battery.
And I have a copy of an amended affidavit that also alleges a violation of rule number 13 and violation of rule number 3.
Yes, those are part of the original warrant that case officer Huff took care of.
What is a violation of rule number 13?
That was it says which states the offender shall obtain the case officer's permission before changing residence. So what he did was he left the state on August 13th, 2020, and without our approval.
Okay. And then what is the violation of rule number 3?
He absconded, and his last contact with our program was October 10th, 2020.
Okay, so does that mean that from October 10th or even from October 10th to at least March 24th, 2021, he had not reported to anyone in community corrections?
Yes.
And on this amended affidavit, it's the number violation is listed. Can you see that and tell the court how many violations he had? What number was this?
This is number 8.
Okay, those are my questions.
Good morning, ma'am. Are you Mr. Mitchell's, or were you Mr. Mitchell's community corrections officer?
I recently inherited the case, yes.
Who did he previously report to?
He in the past reported to case officer Zach Huff.
I'm sorry, what's the name again?
Zach Huff.
Okay, and how recently did you take this on for Mr. Hoff?
I would have taken it mid-December.
Okay, thank you. So you don't have the history of contacts with Mr. Mitchell, do you?
I do not.
Okay, thank you. No further questions, Your Honor.
All right, thank you, Mr. Smith. Go ahead with it.
You come on, step down.
Detective Martin.
Do we have any information, by the way, on the updated
It is.
recent report?
Hannah does. She spoke with.
Yes, it hasn't been done yet.
It has not been done yet.
All right.
You ready for Andy? Thank you.
Yes, sir.
With the date.
You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir.
Hannah, do you know when it'll be ready?
I can ask her, but she's aware that.
Yeah, I mean, we're gonna have to continue to wait for that, so I just,
Okay.
whatever reasonable length of time that's necessary.
Will you please state your name for the record?
Detective Christian Martin.
And how are you employed?
I am a detective with the Metro Nashville Police Department,
And what unit are you assigned to?
Youth Services Division with the child sexual assaults.
I'm sorry, before we go any further, Your Honor, my witness just came in the courtroom, and I think they all need to exit.
Oh, I'm sorry.
Are you the lead detective assigned on a case involving defendant Ronald Mitchell and victim Kamari Kennedy?
Yes, I am.
Will you please just summarize, I guess, your investigation for the court?
Yes. I believe we received this case in the beginning of June of 2020, around that time. It was disclosed to officers, Kamari and Dawn notified police that Kamari had a birthday party in which she stayed over Mr. Mitchell's house. At that time, she disclosed that she was touched over the clothing on her vaginal area by Mr. Mitchell. Subsequently, there was a forensic interview that was conducted in which the same disclosure occurred, that she was over there for a birthday party and she was touched over the vaginal area. There was our kids exam that conducted after that, in which I'd have to review for my investigation, which again gave a similar disclosure. I also spoke with Mr. Mitchell afterwards. Initially, we attempted to do a controlled phone call. It was not successful. A controlled phone call was which we would have Dawn Kennedy call the suspect, Ronald Mitchell, and speak to him about the events. There was no pickup, so that was unsuccessful at that time. If I back up a little bit, we attempted to do that sooner, but because Mr. Mitchell was, from what our understanding, was in a car accident, we were unable to conduct a controlled phone call at an earlier time due to possible medications and him being on there. We didn't want to speak with him and that to be a concern, him to be on different types of medication at that time. Once Mr. Mitchell we presented to the grand jury in which the indictments came out for the aggravated sexual battery. Once Mr. Mitchell was picked up, I conducted 2 interviews with Mr. Mitchell, in which he stated he doesn't remember this specific incident happening. From talking to him, he stated that she did not stay in his bedroom. He said if she was sitting there now, he would tell her he was sorry and it was a misunderstanding, whatever did happen. I asked Mr. Mitchell if he would say that these statements are lies, in which he stated he would not call her a liar, and he could not call her a liar. Just that it must have been a misunderstanding and that he was sorry.
You mentioned about Mr. Mitchell being in a car accident. Did that happen here in Tennessee or in a different state?
At a different state.
Okay, do you remember what state it was?
I'd have to refer to my notes.
Do you have your notes in front of you?
I do not. I
Okay.
believe it was St. Louis, but I could be wrong.
All right, St. Louis.
Yes.
And when you spoke with Mr. Mitchell and interviewed him, was he able to walk without a walker?
From what I seen was just from him in the interview room, and leaving the interview room, there was no walker present.
Okay.
And then when I saw him at the jail the subsequent day, I did not observe a walker.
During the course of your investigation, did you receive the victim's underwear that she was wearing at the time of the incident?
I did. I was advised by the mother that she still had the same pants that the victim was wearing. They had not been washed. They were just still over in the laundry pile area, in which, from what she told me, I believe it was that the underwear was still inside of the pants, kind of as if you just took the pants off with the underwear at the same time. That was picked up. It was sent into the crime lab for testing. I do not have the answer to those results at this time.
Okay.
And then once we spoke with Kamari afterwards, we did get a consensual buccal swab, which again will be tested along with a voluntary buccal swab from Mr. Ronald Mitchell, who was said that it would be good to give the DNA because it would help his case. So we then sent a buccal swab for his DNA to again be compared with whatever the findings are from the crime lab.
I think those are all my questions.
Sir, how many times did you interview Mr. Mitchell?
That would be 2.
And were either of those audio recorded?
They were. Okay.
Both were audio recorded?
Yes, sir.
And Mr. Mitchell did not admit to this crime, did he, during 2 interviews with yourself?
No.
I have no further questions.
One question. Was the house where this incident occurred here in Davidson County?
Yes, it was.
All right. Thank you, Deputy. You may stand down.
Thank you.
Jill Howlett.
If you would, just raise your right hand and be sworn.
You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Will you please state and spell your name for the record?
Yes, Jill Howlett, Jillhowlett.
And how are you employed?
I work at the Our Kids Clinic. I'm a social worker there.
And what exactly is your role? I guess describe your day-to-day duties at Our Kids.
So the Our Kids Clinic is an outpatient clinic of General Hospital here in Nashville, and we do medical exams on children when there are concerns of sexual abuse. We serve all of the counties in Middle Tennessee, about 46 counties, including Davidson County. When children are referred to us from the Department of Children's Services, law enforcement, medical providers, or anyone that needs a forensic medical examination for a child under, or any child up to age 18. And every child that comes to the Our Kids Clinic is met with a team of a social worker and a nurse practitioner. My role while the children are there is to meet with a parent or caregiver of the child by themselves and get some history about what brought them to the clinic. I'm asking, family history, And then how a disclosure came about. I also explained to the parent at that time what goes on during the medical examination. If a child is 5 or over, I get a medical history from that child for the purpose of medical diagnosis and treatment. I take that child into the exam room, show them everything that we're going to do to let them not be anxious about a medical exam. I shared information that I gather from that child. I also have asked the child, do a touch inquiry and ask the child if anything has happened to them. After I talk to that child, I share that information with the nurse practitioner, and then I'm present for the medical examination.
And did you have an opportunity on July 7th of 2020 to examine Kamari Kennedy?
Yes.
And how old was she at the time of her examination?
She was approximately 10.
And did you have an opportunity to follow all the same steps that you've just described with Miss Kennedy?
Yes, absolutely.
Okay. And would you please tell the court about your examination of Miss Kennedy?
Sure. So I spoke with her mother first, and got all of that sort of background history from her. And then I spoke with Kamari in our exam room alone. It was just myself and Kamari. We don't record those conversations because it's a medical visit and you wouldn't expect your medical provider to record those medical visits. So I spoke to her and got some information from her, and I'm assessing all kinds of things about her development, her ability to communicate, and also what she knows about her body. So I'm asking questions like, have you ever had any broken bones, or have you ever had to go to the hospital, or do you take medicine? Have you ever thought about hurting yourself? All kinds of things like that. Because we're also a medical clinic, so we can address other things that may come up with children. And I also ask her what she calls her private parts and what she calls her bottom. We dictate a report and within 24 hours, and that information is it goes to our hospital for a medical record.
And is generating a report on each patient's examination something that you guys do in the regular course of business?
Yes, it is.
Okay. If you could, would you tell the court what it was that Kamari told you?
Yes.
And how that examination went?
Yes, I can read just her part word for word. Kamari reported that she refers to her genital area as her, quote, vagina or kitty cat, end quote, and her bottom as her, quote, booty, end quote. When asked if anyone had ever touched her on her vagina or kitty cat or her booty, Kamari stated, quote, he's sort of my father figure. I see him as my dad, end quote. When asked what happened, Kamari stated, quote, he touched my vagina, but it was on the outside. When asked for clarification, Kamari stated, it was over my clothes, and that was all, end quote. When asked if he touched her in any other way, Kamari stated, quote, no, end quote. When asked if she had to touch him in any way, Kamari stated, quote, no, end quote. And Kamari reported she has never experienced any other type of sexual contact by any other person.
And when the nurse practitioner examined her, were there any physical findings?
No, her exam was what we would consider normal. It was without any signs of acute or chronic trauma. And that's what we expect in most of our cases.
Okay. And does that in any way indicate that there was or was not abuse?
No, it does not.
Those are my questions.
Ma'am, about how many of these interviews do you do with potentially abused children a year?
Since August of 2011, I've done approximately 2,000.
And is there anything in this interview that you felt was unusual or different or something that maybe caught your attention?
No.
Based on based on your interview, were you of the professional opinion that the child had been sexually contacted by someone?
I can tell you what she told me, and that her exam was normal, which is what we expect to find in most of our cases.
There was nothing in what she said that would indicate vaginal penetration, correct?
No.
No, that's not correct, or?
I'm sorry.
No, there was nothing that indicates that there was.
There was nothing in her statement that indicated vaginal penetration.
Okay. Thank you.
Thank you. Call the next one.
Your Honor, I believe that's all the witnesses for the state.
Now we gotta continue for the re-sentence.
Yes, and I would just ask for the sake of efficiency, if Your Honor recalls, we had the bond hearing on this last time where it was kind of lengthy and I went through his entire history. If Your Honor would accept incorporating that testimony by reference to this hearing, that's what the state would ask in order to not go through all that again.
All right.
Your Honor, if I may propose, since we're waiting for the pre-sentencing report, why don't we bifurcate the hearing? Because
Bifurcate your.
And the reason I asked, Your Honor.
We're gonna bifurcate it, or you want to bifurcate it at this point before you put on proof?
I think so, because.
Give me a date. Because it's gonna be bifurcated.
So the reason I asked the court for that is because the gentleman's community corrections officer had historically been a Mr. Hoff. And so I'd actually subpoena to have him present. He could actually substantially answer more questions.
Okay, I don't have a problem with it. If you got any other witnesses you want to call today, or you just want to bifurcate it now?
I do have a witness that we're going to put on, and I do believe that Mr. Mitchell would like to, but we could do that all together. We could put on.
I ask you which way you want to go, Mr. Perry.
I think I would rather put on defense proof all in one day. Your Honor.
Okay, thank you. Let's get the date for that.
We have any idea how long this is?
Pre-sentence report, you got an estimate on estimated time of arrival?
I do not know. I'll just ask her how quickly she thinks she can do it.
Sure, just give me 3 weeks.
We'll probably be in trial. Do the second or third of
June 2nd. Okay? That'll give you plenty of time to get that done.
And we'll need any information on who you need subpoenaed.
Yeah.
We're ready to do these, well, what are we doing? I'm not gonna try and take that.
Yep, you got scared. Next is Cully Springer,
But you said 10 o'clock, and then it's 10:20.
and that's pretty good, go close. Salvador didn't get here at 8:30. No. No, we probably won't be done that way. Okay.
Who'd you say, Mr. Smith?
Cully Springer.
Hopefully it's free. What are you gonna do for Sunday?
I don't know what they're gonna do. Our own street, 16 feet. Like lower, it's recessed into the city.
Oh, it's a recess. Yeah, some of those. Ours didn't.
Yeah, I don't like the idea of it.
Ours is more than 9 minutes. Sketchy.
I think I'm gonna bring in someone that's planning to change all 4 of them.
The same time.
Yeah, with the light bulb now, they last like 10 years, kind of stuff. Yeah, just get it off the button.
Is it an announcement shop or is it here? Okay, so I'm sorry.
See you back tomorrow.
No, there's officer here, they'll be next.
It would be a very here, short area.
Somebody get one.
Let's do this then.
Somebody get.
All right, we're first alphabetically. I'll call Mr. Coley.
Mr. Foley, let me get you to step right over here. Raise your right hand, please, sir.
You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Step over and see that officer, please. Step over, Foley, come up, sit down with Mr. Chair. All right, please, sir. Step over, Foley.
And Mr. Coley, please state your name for the court and spell it.
William Coley, WILLIAMCOLEY.
Okay. And Your Honor, can you take the mask off?
Yeah.
Okay, thank you. Mr. Coley, you can go ahead and remove your mask instead of pulling it down every time. So, Mr. Coley, obviously you understand why we're here. This is a post-conviction relief claim that you filed about 3 years ago. Is that right?
Yeah.
Okay. And you might need to move that microphone so it's a little closer to your mouth. Thank you. And Mr. Coley, today primarily we're going to be talking about kind of your pre-trial interactions with your attorney, and then some of the things that happened during the trial. Okay. And then a couple of things that happened after the trial with the appeal, but primarily we're going to focus on some of this pre-trial preparation now. One of the grounds laid out in our petition is that you felt as though you and Miss Anna Escobar were not thoroughly prepared to go to trial on this case. How many times do you believe you guys met before the trial on this matter?
Handful of times. I couldn't give you a direct number, but
You have one handful, two handfuls?
like 2 handfuls, about 7 times, probably something like that.
And Mr. Coley, you're really soft-spoken, so let's.
I said about 7 times.
Thank you. That's good. During the pendency of the case, did you have opportunities to speak with Miss Escobar over the phone or using any kind of letters and things like that?
Yeah, she had came and seen me a few times when I was at the church center by Blackwood.
When she came to see you, did she bring a private investigator with her, or was there any other person that accompanied her?
No, it was just her.
Okay. Did you ever meet with a private investigator regarding this case?
Yeah, one time.
Do you remember who that was?
I can't remember his name off the rip.
Do you remember the content of that conversation and what you guys talked about?
Pretty much he was just telling me he went by the crime, they went by the crime scene. That was pretty much it. It really just went by the crime scene and had tried to talk to a couple of witnesses, but that was it.
And was that the only time you ever worked with the investigator on the case?
Right.
Okay. During your conversations with Miss Escobar, were you ever conveyed any offers to plead guilty in this case?
She had said they came to me one time to offer a 40. It was a 40 or a 30. Like, nah, we going to trial. She like told them we're going to go to trial on it.
Okay. Did she talk to you at that time about how much time that would actually mean in custody, or why it might be a good idea to take a plea? Did you discuss that potential guilty plea very much?
No.
Okay.
When she said that, I told her we're going to go to trial, that was really the conversation.
We said going to trial. She said she was going to, y'all were going to trial, or you said no, I'm going to trial.
She said, no, we're going to go to trial because it was, they offered a 30 or a 40. It was one of them two. I can't remember exactly which one it was.
Okay. Did she tell you that she thought that that offer was bad, or that you could beat the case at trial?
Yeah, she was just like, that's not a good offer.
Okay.
30 or 40, that wasn't a good offer.
Do you recall ever making a counteroffer and saying, hey, you know what, I'd take this much time if the state would offer it?
No.
Okay. So it's pretty much just preparing for trial at that point in time.
Pretty much.
Mr. Coley, had you ever been in a jury trial previous to this one?
No.
And obviously you haven't been in one since, correct?
Correct.
So did you understand all the work and all the different kind of preparations and evidentiary things that would go into preparing for a trial like this one?
No.
One of the things that was really important was that your co-defendant apparently had made some statements. Is that right?
Right.
Did you and Ms. Escobar talk about those statements and whether or not they were going to be able to come in front of the jury? Or in other words, whether she thought they were hearsay?
It was just pretty much everything was hearsay. She was just telling me it was hearsay. It'll be all right. It won't go against me.
Okay. Do you understand what hearsay is?
Kind of. Yeah.
Kind of. Can you give us a definition for hearsay as we sit here today?
Just hearsay is basically what someone else heard. Is no proof, and it is they didn't actually see it or anything like that. It's just what they heard from someone else.
Okay. And that's your understanding of what the hearsay rule is.
Right.
Did Ms. Escobar ever go over the actual hearsay rule with you and tell you what it meant?
No.
Okay. But she did tell you that because it was hearsay, these statements weren't going to be able to come in. Is that right?
Right.
Okay. And some of these statements were particularly damaging, as far as you remember, correct?
Correct.
Did not Mr. Springer allegedly say that you shot this gentleman?
Say it one more time.
Did Mr. Springer allegedly say that you were the one that shot this gentleman?
No, I can't really remember. You said I can't say the question one more time.
I'll try again. Did Maurice Smith testify that Mr. Springer told him that after William got shot, he shot the guy and watched him take his last breath?
Yep.
Okay. Did you understand that at that point? Did you think that was hearsay and that wasn't coming in?
Right. I thought that was hearsay.
Okay. Did Ms. Escobar explain to you that it wasn't hearsay because a defendant actually was the one who allegedly made that statement?
No.
Okay. So that kind of moves into our next chapter of what I want to talk to you about. Because these statements that Mr. Springer made were so damaging to you, did you and Ms. Escobar talk about severing you from him at the trial?
Yeah, I talked to her about that. I talked to her about trying to get it separated, trying to have a suppression hearing.
Okay. And those are two different things, but let's talk about the severance thing first.
Right.
When you asked her if you could get separated from your co-defendant, Mr. Springer, what did she tell you?
We really didn't have too much of a long conversation on it. It was just like, I'm going to see how we can do that. But it really wasn't a long conversation about it.
Okay. Did you ever have any pre-trial hearings about separating you from your co-defendant?
No.
To your knowledge, did Ms. Escobar ever file a motion to separate you from your co-defendant?
The only thing I can remember when at trial, we was trying to get separated then, but it didn't happen.
Okay, and that was based on something that actually happened during the trial, right?
Correct.
Okay, but in terms of preparing for a trial, getting ready and filing pre-trial motions, you never had a hearing about whether or not you and Mr. Springer should be severed from each other. Is that correct?
Correct.
Likewise, you mentioned suppression. You didn't have any hearings about suppressing any of the evidence in the case, right?
Right.
Now, some of the evidence in this case is a little bit stronger than others, okay? I want to ask you particularly about the DNA evidence in the case. Did you talk about that with Ms. Escobar when you were preparing for trial?
Yeah, a little bit. Just really, just what did they find, or what was how did it go really?
Okay. And what was your understanding about what they found and how they were going to use that against you?
The understanding was they found a speck of blood, stereo piece, and that was it.
And why was that blood important?
It was important because it could have put me at the scene of the crime.
Right. Okay. So
where was this blood found?
It's still on a stereo piece, a speck of blood on a stereo piece.
And that was allegedly in the office where they found this gentleman deceased, correct?
Correct.
Okay. So they had a speck of blood that your understanding was could put you at that scene, correct?
Correct.
Did you ever talk to Ms. Escobar about getting a DNA expert or a blood spatter expert or somebody like that who could look at this evidence and maybe testify on your behalf and help the jury understand that evidence?
Right. That was why I wanted to do a suppression here on different issues, but that was one of them trying
to keep the blood out, right?
Right.
That was probably a very important thing for you in this case, right?
Right.
Because if the blood can put you there, then that becomes a lot more difficult for you to argue that you weren't there, right?
Right.
Did she hire a DNA expert as far as you know?
No.
Or any kind of forensic expert to talk about blood spatters or anything like that?
No.
Okay. So you didn't have those experts. You didn't have any pretrial motions about suppressing that evidence. What was your understanding going into the trial? Was it that they were going to be able to introduce that evidence?
I really didn't have a total understanding of what was going on. Really, I wasn't knowledgeable. Still not really knowledgeable of the law. So
yeah, and that's fine. Mr. Clay, nobody expects you to be a legal expert. Did you think that maybe during the trial you'd have arguments about whether or not this evidence could come in?
Right.
But at the time, you hadn't seen anything and didn't know what that was going to look like, right?
Right.
During those conversations, when we're talking about DNA evidence coming in against you, and then statements that Mr. Springer made that could also be coming in against you, did you have a conversation with Ms. Escobar about, hey, look, this all is starting to look pretty bad. If they can put me at the scene of the crime, I'm going to be in trouble here. What do you think about a self-defense argument rather than a it wasn't me argument? Did you talk to her about that?
No, we never talked about a self-defense claim or argument.
Okay. Having reviewed, obviously, the evidence in this case, and for the last 10 years, sitting in custody, kind of going over everything, do you think that a self-defense argument might be something that would have been helpful in this case?
Yeah, it would have been helpful.
Okay. Did you even discuss with Ms. Escobar what your testimony would look like if you were to testify on your own behalf?
No.
Did you ever prepare any testimony or go over any potential direct or cross-examinations on this case?
No.
Did you both decide that self-defense was a bad argument, or was that just your attorney, or was that just you? Do you remember how that went?
No, I really can't remember. I never brought it up. So, like I said, I don't have any knowledge of the legal or how to do it. So,
but sitting where we are now, 10 years later, is that something that you would have thought would have been helpful to understand at the time?
Yes, it would.
And if you had a self-defense argument, is that something that you would have considered testifying at trial in support of?
Right, yes.
Some things happened during the trial. Obviously, you referenced that earlier where Mr. Springer allegedly made some statements to some other witnesses. At that time, did your attorney make a motion to sever you guys from each other?
Yeah, that's when she tried to do the severance, but it didn't happen.
Was that the first time you heard anything during the trial or previous to the trial in this courtroom about separating you two as defendants in this case?
Yeah.
Okay. And you remember that motion was denied, correct?
Correct.
Okay. Finally, Mr. Coley, you did not take the stand in your defense, right?
Right.
You weren't prepared to do that in any way.
Right.
There was at the end of the state's proof and at the end of defense proof, there was a decision not to do a closing argument. Do you remember having a conversation with your attorney about that?
Yeah.
Okay. And there was also, I believe, a piece of paper that you signed agreeing to waive that closing argument. Is that right?
Right.
What was your understanding about why we were doing that and why that happened in this case?
Just how it was two of them, Ms. Davis and McGuire, and like she'll go first, then we will go, or you know how that goes. While that whole time while we're doing it, or she went first, he'll be on his power, trying to put his PowerPoint together, getting everything together, so he will go last. So we end up coming with that strategy.
Okay, and so you just said the word, it's strategy, right? Did that seem to you to be a strategic decision rather than some other kind of decision?
At that time, yeah.
But I don't understand what the strategy was.
To waive the closing argument.
No, but the reason why, what was the reason that y'all chose to waive it?
The reason was because, all right, well, she went first, and then we would go. And the whole time.
Ms. Escobar?
No.
Ms. Davis.
Ms. Davis.
Ms. Davis,
General Davis.
Oh, okay.
So the state's first closing argument, and then the defense would put on their closing arguments, was your understanding, right?
Right.
And during that entire time that they'd be making that closing argument, Mr. McGuire would be over here with the laptop or whatever, putting together a PowerPoint that would be something that he would argue against you guys in his closing, right?
Right.
Did you and Ms. Escobar ever go over what her closing argument would be?
No, we never came up with one.
Okay. You didn't review that with her at any point?
No.
To your knowledge, was there ever a closing argument that was prepared in this case?
Not to my understanding.
Okay. Mr. Coley, thank you for your answers to my questions. I don't have any further for you. General Harris will have some questions for you now.
Good morning, Mr. Coley, and I'll be brief as well. There's a lot of legal things that your attorney has brought up, but we'll stick to the stuff that you were witness to. Let me start with this. You said that Judge Escobar now, but Ms. Escobar at the time, met with you multiple times, but maybe a handful of times. Is that correct?
Correct.
Is there anything about this case that you wanted to tell her that you never told her?
What do you mean? Like,
is there anything that she didn't know that you wanted her to know?
Nah.
Okay. So let me ask you this. Did she go over with you the proof that was coming out at trial?
Really, like when she would come see me, she bring like tape recordings from them cross-examining the witnesses, or like really just going over what they had.
Mm-hmm. And you understood. And let me ask you this: you talked about Mr. Springer's statements. It's true, isn't it? The Mr. Springer statements that came in. One of them is that Mr. Springer had shot the victim. Is that correct? Not you. Is that correct?
Over here, so yeah.
Okay, so the statement that came in at trial was that you didn't shoot the victim, that Mr. Springer did.
Right.
Another statement that came in is that Mr. Springer had the gun from the victim, not you. Is that correct?
Correct.
So isn't it feasible, Mr. Coley, that Ms. Escobar at the time of this trial was using a strategy that put the gun in your co-defendant's hand and the stolen item in your co-defendant's hand and not yours? Is that correct?
I can't say that because we never went over a strategy. So.
Okay, let's talk about that. You want to talk about strategy. What was the strategy you wanted to put forward?
Well, like I was saying, I wanted to get a severance and try to get suppression, and what we didn't end up doing.
Okay.
So,
Do you know of any reason why any of the evidence in this case should be suppressed?
Say it one more time.
Do you know of any reason why any of the evidence in this case should be suppressed?
Yeah, as far as with the witnesses, yeah.
Okay.
Their statements was never consistent. It was always something. The DNA, it was different things I wanted to suppress.
Okay. You understand though, but do you know, and this is an unfair question, I know that, I'm just asking. Do you know of any legal reason why any of that should be suppressed?
Like I said, I'm still trying to learn legal law, so.
That's fine. And let's talk about severance. Why do you believe a severance would have been good for you in this case?
It would have been good for me just from not putting us together. They couldn't put us on whatever my co-defendant, whatever they say he did or whatever, it wouldn't have put me with him. It would have been a separate trial.
Okay. Let me think through that. So you don't believe if a severance, they couldn't have talked about you and him being together?
Probably not, no.
Okay. All right. Okay, Mr. Coley, and let me back up a bit, because I'm not going to argue with you, but the reasons why we're here today is you believe you should have been severed from your co-defendant, and you wanted some things suppressed that came in at the trial. Is that correct?
Yeah, among other things, but yeah.
Okay, what else?
So it's a lot of things. I got a lot of issues that's on record. So, it's a lot of things that's on record that could have done, but didn't do so.
But at the trial level with Miss Escobar, the things that bothered you most were that you had to be tried with your co-defendant. Is that correct? And you didn't want that to happen?
Right.
Okay. Nothing further at this time, Your Honor.
Anything else?
Yeah.
All right, then, thank you, Ms. Cole. You may step down, sir.
And Judge, we're doing these together. I would ask for Mr. Springer.
Yeah, we'll go ahead.
Let's do that, and then we'll put on both.
Let both the petitioners put on
Thank you, Your
there.
Honor.
And Your Honor, that is our proof on that, Mr. Cole.
All right.
Your Honor, I call Mr. Springer.
Springer, let me get you to stand, raise your right hand, please.
Solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
And Your Honor, for procedure's sake, I have some dates. 11/5/15, Mr. Springer filed a pro se petition. I have sometime of September of 2016, Mr. Brand, his attorney at that time, filed an amended petition. Mr. Springer told me that at some point in 2017, he also filed a second pro se petition, which in part was asking that Mr. Brand be relieved, but also I think raised some additional issues. And then I filed a post-conviction petition on September the 6th of 2017 that added additional issues. We would be proceeding on, and if the court could incorporate all of those together. And I think the state has all of those, I believe.
Yes, and I assume, Mr. Kelly, the same on yours. I mean, because you had, what, 3 amended petitions or something like that as well?
Yes, Your Honor, and whether we reference those or closing argument now, yes, those will all be part of the record.
All right.
Okay, Mr. Springer, you're sort of soft-spoken, so make sure when you talk, you get into the microphone, okay?
Yes, sir.
All right, so you're aware of the procedure.
That's what you're pointing to.
You're aware of what we're doing here today, right?
Yes, sir.
And obviously, Mr. Brand helped you before and you filed your own pro se petition, and then we've talked several times. So you understand what you're asking the judge to do.
Correct.
You said that Mr. McKinney was ineffective as your attorney both during your trial and on appeal, and you're asking him for Judge Fishburne, for a new trial and or a new appeal.
Yes, sir.
Okay. You've reviewed all the petitions that we've just mentioned today as well as in the past, and you have approved of everything that's been filed, right?
Yes, sir.
Okay. I want to talk first a little bit about your interaction with Mr. McKinney. How long was he your attorney
prior to trial? Do you remember?
He became my attorney right after, I say maybe 5 to 6 months after the preliminary hearing.
Okay, so Ms. Lawson from the Public Defender's Office had represented you at the preliminary hearing stage, is that right?
Yes, sir.
And then after your case was bound over and indicted, your family retained Mr. McKinney, is that right?
No, sir, he was court.
He was appointed, okay. So in criminal court and Judge Fishburne's court, he was your only lawyer?
Yes, sir.
Okay. And this case, from the time that you had the arraignment and Mr. McKinney became your lawyer to the time that you actually had the trial was approximately a year or two, is that a fair guess?
A little over a year.
A little over a year. During that time frame when Mr. McKinney's your lawyer, can you tell the court about how often you spoke with him and what way you communicated with him, what kind of information he gave to you, things like that?
I received maybe 3 letters. Usually when I talk to Mr. McKinney is whenever we had a court date, like for the, I think they call it a discussion.
Yes.
They like, the first discussion I spoke to him, we were supposed to originally go to trial in November 2010.
Okay.
They put it off. I talked to him then, and then maybe 2 more times before trial.
Okay. You said that you usually spoke with him when you came to court on discussion dates when you were trying to negotiate about maybe having a plea, and we'll talk more about that in a second, but how many times do you think you spoke with Mr. McKinney at the courthouse? Not counting your trial, I mean prior to before.
Maybe 3, 4 at the most.
And you say you received approximately 3 letters, you think, over the year or so?
Yes, sir.
How many times did he actually come to see you at the facility where you were being housed at the time?
No more than 5.
So you spoke with him face to face somewhere between 5 and 10 times over the course of the year?
Yes, sir.
Okay. During those conversations, and like I said, we'll talk about the plea negotiations here in a second, but during those conversations, did he talk to you about the evidence the state had against you for trial?
Yes, sir.
Did he provide you a copy of the written discovery that he had been given by the state?
Yes, sir.
And did the 2 of you talk about that together?
Bits and parts.
Okay. You had access to all the information though yourself?
Yes, sir.
Did you ask him questions about it?
Yes, sir.
What kind of questions did you ask?
Pretty much was about like the hearsay, well, quote unquote hearsay testimony.
Okay. When you say that, you're talking about what witnesses later testified at trial that you had supposedly told them?
Yes, sir.
Okay. So you had questions about what these witness statements would be and how that would work at the trial?
Yes, sir.
Okay. Let's talk a little bit about the trial itself. Did you understand sort of the mechanics of the trial, how it worked? You know, who got to call witnesses and when, and whether you testified or not, and what your defense strategy would be or anything like that?
Yes, sir.
Okay. What kind of conversations did you have with Mr. McKinney about those things?
Well, pretty much like what he explained to me was the state was going to present their proof. And after the state present their proof, we're going to present our proof.
Okay.
And then the closing arguments, you know, just the regular stuff that goes on in the trial.
Okay. So you understood how it was all supposed to work?
Yes, sir.
Did you talk about your right to testify and then talk also about whether it was a good idea or not for you to testify?
Yes, sir.
And what were those discussions like?
Well, he told me what he was explaining to me, this being my first felony, he was like, it will be okay to get on the stand, but he advised me not to get on the stand.
So by okay, he meant, or you took it to mean that you didn't have a record that they could use against you on the stand?
Yes, sir.
But he didn't think it would be a good idea?
No, sir.
What were your opinions about whether it was a good idea or not?
At the time, I was new. I didn't know nothing about the law, so I just pretty much, whatever he said, I just nodded and agreed.
Okay. But you understood that even if you didn't agree with him, you still could have testified if you wanted to, right?
Yes, sir.
Okay. As far as other things, questions that you had about evidence that the state might have used, you mentioned the hearsay. Were there other things that you talked to Mr. McKinney specifically about?
About the nature of the, especially aggravated robbery.
Okay. Could you explain further?
Like, I was asking him what was the burden of proof because
they never once proved the existence of the gun. And he just kept saying, well, the witness is saying that you had it. But I kept asking him, where's that proof?
Right. Did you guys discuss how, there's physical proof, like the actual firearm, and then there's other types of proof, like what a witness statement might be is also proof?
He said circumstantial evidence, I think that's what it's called.
Okay. And you said the burden of proof, did he tell you or talk to you about what the state would have to prove in order to have you found guilty?
Not so much. He just told me, like, far as before we went to trial, he was just like, the whole strategy was to make the state prove their case.
Okay.
Pretty much.
You mentioned that you understood you had the right to put on evidence. Also, you could testify, but you had the right to put on evidence. Did you and Mr. McKinney have any evidence that you thought would be good to put on?
No, sir.
So you were going to just make your case and trying to cross-examine the state's witnesses?
Yes, sir.
Okay. Kind of in the same idea, what was your strategy at trial? I mean, you put the state to their proof, but was there a specific thing that Mr. McKinney said, if we can show this didn't happen or we can show this is unreliable, then that's our goal on how we're going to do that?
He just said his goal was to have the state prove, like, what he basically said to me is I had a 50-50 chance. He was like, our strategy was to make the state prove their case.
Okay. You said a minute ago that you talked to him about legal issues. Did you, obviously you had the trial ultimately with Mr. Coley, but did you talk about having a separate trial or having a severance of your case away from his?
Yes, sir.
And what were those discussions with Mr. McKinney like? What did he have to say?
He first mentioned it in a letter when we had our first discussion. They had offered me a second degree murder with 40 years at 100.
Okay.
And he advised me not to take it. And
okay.
Then,
well, hold on one second. I'll talk about the plea negotiations here in a second, but I mean, I'm talking about having a separate.
Yes, sir. I was.
Oh, I see. Okay.
It was all part of one letter.
Oh, okay. Sure.
And also in the letter, he had notified me that he was going to ask for a motion of severance because he was saying it was a lot of damaging evidence against my co-defendant that had no, I don't know how to word it, but it really didn't pertain to me. I guess that's how you would say it.
Mr. McKinney felt it wasn't relevant to you, but it still could be damaging to you.
Yes, sir.
Okay. Do you recall what evidence exactly he was talking about?
Well, with the DNA, the clothes, it was more of the DNA.
And that was what was found of the speaker that we heard about? Had blood evidence that had Mr. Coley's DNA on it?
Yes, sir.
Okay. And it did not have yours, but it was still perhaps incriminating for you?
Yes, sir.
Okay. So Mr. McKinney discussed filing a severance, but to your knowledge, did he ever file anything with the court asking that happen?
No, sir.
You say that he told you about this in a letter. Did you ever follow up and talk with him about it after that letter?
No, sir.
Okay. So you were talking a little bit about negotiations or settlement negotiations. You said that Mr. McKinney, told you in a letter the state had made an offer of 40 years to serve on a second-degree murder?
Yes, sir.
What response, if any, did you have to that? I mean, you say he advised you not to take it, but what did you tell him?
Well, to that one, I told him, I just agreed and said, okay, I'm
You disagreed with the offer or disagreed with his position that you shouldn't take the offer?
I agree with his position that I shouldn't take the offer. Yes, sir.
You said for this one, did you get a second offer or did you have more negotiations at some point about this?
He told me about one more offer before trial.
Okay. What was that offer that you recall in addition to the 40-year offer?
He had came see me at the Justice Center.
Okay.
And he said the DA wanted to offer me at 30 years.
Okay.
And I turned it down. I personally turned it down.
Okay.
He had wanted me to accept it.
Okay. So initially you get a 40-year offer, which you reject, and he also thinks is not a favorable offer. And then later, closer to trial, you have a 30-year offer that you also reject that he thinks perhaps is a good deal.
Yes, sir.
Did you make or instruct him to have any counteroffer to this 30-year offer that you got?
Yes, sir.
And what was that you asked him to do?
I had asked him to counteroffer with 15 years.
Okay. To your knowledge, did that ever happen?
No, sir.
Did you ever talk to Mr. McKinney again after that day about settlement?
No, sir.
Why didn't you bring it up with him again?
Truth be told, about time I seen him again, it was trial time. It was like we was coming through that door right there, and
okay. When you say he came to the Justice Center and talked to you and had this 30-year offer, how close in time was that to the trial itself?
Maybe a few months.
And then the next time that you saw him was the day of trial, the morning of?
I seen him one more time before that, like a couple of days before trial, was pretty much was to tell me how we was going about with the trial.
Okay. And during that conversation, you never asked him what happened with your counteroffer of 15 years?
No, sir.
Would you have been willing to accept an offer greater than 15 years?
Yes, sir.
Were you aware of not whether the 30-year offer was still open at the time that you talked to him next?
No, sir.
But you just didn't really ask any further?
No, sir.
But you're telling Judge Fishburne here today that you would have accepted an offer greater than your counteroffer had you been able to negotiate that out?
Yes, sir.
Why didn't you pursue it any further with Mr. McKinney?
Truth be told, the way he had me feeling, I felt good about the case that we had going to trial.
Okay.
So after the 30-year sentence, like, we had a discussion, like, it was a pretty much, when we discussed the 30 years, it was a back and forth discussion. Like, he told me 30 years. I countered with the 15. He hit me, he came to me again the same day, was like, well, the charge don't carry no less than 20 years or 85.
Okay.
And so.
By the charge, were you talking about especially aggravated robbery, or were you talking about a reduced homicide charge?
A reduced homicide.
Okay. Well, so did you discuss about pleading out of range with him at all? Do you know what I mean when I say that?
I guess you mean like enhanced.
Well, normally if you had no prior felonies, you wouldn't be able to get a 30 or 40-year sentence for a second-degree murder, but if you agreed to it, you could.
Yes, sir.
Did you talk to him about that?
Well, I had a discussion with him that I knew about the ranges.
Okay. Did you, to your understanding, could you have pled whether Mr. Coley agreed or not? I mean, were they contingent on each other, or you could have pled and he could have had a trial, or he could have had a trial and, I mean, you could have pled and you had a trial? Did you know?
He never mentioned either way. He just, once he told me about the counter offer, he also told me like the DA was going to go to my co-defendant to try to testify against me, but he never brought up what you just said about I couldn't sign if he couldn't sign, or what if I signed, he go to trial.
Well, your understanding was, though, if you agreed to the 30 years or the 40 years and signed for it, that was good.
Yes, sir.
Okay. I want to talk a little bit about Mr. Green. He was another person that the police had investigated.
Correct.
And I mentioned a minute ago that Ms. Lawson had been your attorney initially during the preliminary hearing stage.
Yes, sir.
Later on, it became apparent that Mr. Green was also her client. Is that right?
Yes, sir.
Okay. And Mr. McKinney was aware of this?
Yes, sir.
And he mentioned that in his opening argument. Is that right? Or he mentioned it to the jury during trial. Is that right?
I do not remember.
Okay. Did you think that Ms. Lawson had any information about you that was confidential that shouldn't have been disclosed to another client?
Yes, sir, because she represented me at the plenary hearing, so she knew about the case.
How do you think that affected the situation with Mr. Green one way or the other?
Truth be told, I really don't know.
Well, you saw his name, initially, or in the discovery that you had received from Mr. McKinney. So you knew he was a potential witness pretty far back, right?
Yes, sir.
Okay. And you knew that he was not going to be a favorable witness for you.
Yes, sir.
Did you ever talk to Mr. McKinney about what is sometimes a defense strategy of suggesting an alternate suspect to the crime to the jury?
I want to say no.
Okay. I want to talk a little bit about Ms. Reese. she was a primary witness for the state during the trial, is that right?
Correct.
Okay. You talked to Mr. McKinney about her during the course of his representation, is that right?
Yes, sir.
Okay. What do you recall your discussions with him about Miss Reese to be?
Just, she was a damaging witness and she was represented by Miss Lawson too.
Okay. And was that all that you recalled that the only discussion that you recall having with her, with Mr. McKinney about her?
Yes, sir.
Okay. For 1 second, Judge. Just to circle back, though, to, just to circle back, you had an offer and made a counter offer, then that sort of just fell by the wayside. Are you telling the judge here today, though, that, suppose the state said, 30 years is that's the best I'm ever going to do. And Mr. McKinney came back to you and said, I talked to him about 15, talked to him about 20, I talked to him about 25, they won't budge. What would you have said if you had had a conversation like that with Mr. McKinney before trial?
I would ask him to try again.
Okay. So would you have accepted a 30-year offer at any point had it not changed?
At that particular time, no, sir.
Okay. But you would have accepted a homicide, you would have accepted a significant period of incarceration.
I would accept it within my range, yes, sir.
Okay. So the range being up to 25 years, you would have taken up to that?
Yes, sir.
Okay. Did you convey that to did you tell Mr. McKinney that, though, specifically?
No, sir.
But you're telling Judge Fishburne that was the case?
Yes, sir.
So you thought you were sort of still in the negotiating process and then kind of found yourself in the middle of a trial?
Yes, sir.
Okay. I think those are all my questions right now, okay?
Mr. Springer, once again, I'll be brief. I'm just going through your petitions that were filed. I won't take a lot of your time. But very similar to Mr. Coley's question, is there anything that you felt that Mr. McKinney should have known about this case that he did not know?
The chain of custody with the DNA.
Okay.
Like at trial, it was more evidence about the clothes, the location of the clothes and the shell casing that wasn't discussed in the discovery or even at the preliminary hearing.
Okay.
I'm trying to think.
You're talking about it changed hands more than you realized before the trial?
Yes, sir.
Okay, so basically the what you're saying is that it should have been more investigative how that ended up in the custody of the Metro Police.
Yes, sir.
Okay. And what else? What else should he have known?
Well, that for the most part, he pretty much knew everything.
Okay. Okay. Is there any argument that you wanted him to make that he didn't make, and you told him about, but he refused to make it?
Well, with the robbery, to me, they never proved the robbery. Like the detective said, it was no fourth entry. When nothing took him from the business, the victim still had like $900 in his pocket or whatsoever, and it was like the only proof of a robbery was hearsay witnesses.
Okay. Okay. And I'm going to dispute you a little bit, but I know we're getting into something. I know you've not been to law school, but I'm going to dispute you a little bit. But you understand that under felony murder, whether something was taken or not, if the goal was to go commit a robbery and someone is killed, Still guilty of felony murder.
Yes, sir, I understand.
Okay, so you know the proof in this case said that you and Mr. Coley were discussing a robbery and then left and then came back and Mr. Coley was shot. And then you said you shot the guy and watched him die.
Allegedly.
You know that's what came out at trial.
Yes, sir.
Okay, so the fact whether or not this gun, although there was testimony that you had a different gun, a new gun, 2 guns when you came back, regardless of that, discussing a robbery, going somewhere, that can still convict you of felony murder and everything ran concurrent. You understand that?
Yes, sir.
Okay, so regardless of whether anything was taken, doesn't ultimately matter to the felony murder conviction. Okay, so what else?
They never even proved that we had a discussion about robbery.
Okay, but you understand that's what people said at trial?
Yes, sir.
Okay, and you said you wanted to be severed from Mr. Coley. Why did you want to be severed from him?
At the time, Rob felt like that was the best situation for me because it was more damaging evidence against him with his DNA being at the scene of the crime.
Okay, so you wanted to be severed, and did he file a motion to sever you?
No, sir.
Okay, and do you know of any, and it's unfair, and your attorney may argue this, do you know of any legal reason why you could have been severed from him?
No, sir.
Okay. And you understand on this counter offer, you were offered 30 and you turned that down. Is that correct?
Yes, sir.
And you would turn that down today?
No, not today.
No, I'm sorry. No, I didn't, but that's an unfair question. You turned that down at the time and you were going to turn that down up until trial time?
Yes, sir.
Okay. That was an unfair question. I apologize for that. I've got one more question. Your attorney talked about you had a different attorney at General Sessions level. Is that correct?
Correct.
And that same attorney also represented Tabitha Reese. Is that correct?
Correct.
And one of the claims in your post-conviction was that that Mr. McKinney should not have mentioned the fact that you and Ms. Reese had a similar attorney. Is that correct?
Yes, sir.
Okay, but you agree that tying in a state's witness to you to show some favoritism, that was a strategic decision. That's why he did it. Is that correct?
I really can't speak for that.
Okay, but if Mr. McKinney says that, there would be a logic of, oh, look at this attorney is now passing on information. That was the implication. Is that correct?
Once again, I can't speak on that.
Okay, that's fair. Nothing further, Your Honor.
Just a few things, Judge. Mr. Springer, on that note, I confused myself, which is not very hard. So Ms. Lawson did not represent Mr. Green, she represented Ms. Reese.
Correct.
That's okay. So as far as Mr. Green went, he was a potential suspect at one time that had been interviewed by the police.
At first, yes, sir.
Okay. And Mr. McKinney wanted to explore that with the jury, but he was prevented from doing so.
Yes, sir, because he was deceased.
Okay. Do you have any idea what an offer of proof is?
No, sir.
Okay. There was no, Mr. McKinney didn't make any attempt or was not successful in including Mr. Green's statements for the review of the appellate court because they were excluded, right?
Correct.
Okay. As far as the situation with Ms. Lawson and Ms. Reese, you think that Mr. McKinney should not have made it clear that you guys shared an attorney?
Correct.
Okay. One more thing. You also elected to waive your closing argument. Is that right?
Correct.
And you said that Mr. McKinney had advised to do that. Is that right?
Correct.
And that he actually advised you that that was a strategy he wanted to try prior to the trial even happening. Is that right?
Correct.
Okay. So regardless of whatever the testimony may have been, he told you he wasn't going to do a closing even before the first witness was called?
Yes, sir.
Okay. Did he say why he thought that would be a good strategy?
Well, what he explained to was pretty much the same thing Mr. Kohler just testified to was Miss Davis would give her closing argument first. Then our side would give a closing argument, and that would give, I guess his name McGuire.
Mr. McGuire, yes.
It would give him time to come up with, his thoughts and stuff, prepare off based off what we said, and counter.
So the thought was Ms. Davis's argument would not be a complete one because she would anticipate Mr. McGuire finishing it?
Yes, sir.
And if she wasn't given the opportunity, that would help you?
Correct.
Okay. That's everything I have then.
Just for clarification, what is it that there was mention made by your attorney, Mr. Russ, about an offer of proof being made on Mr. Green's testimony? Was he dead at the time as well?
Correct.
And what was his testimony? Do you know what his testimony would have been?
No, sir.
Do you know if it would even have been admissible? When did y'all discuss that, or?
Judge, I can refresh the court's memory. It's been a while, I know.
I haven't looked at
The appeals opinion, you did not allow it in based on relevance. And so that was the reason it was not let in. The story goes that he lied to the police about where he was. He was on video. They confirmed, they never could tie him to the scene. They confirmed that he had lied for his girlfriend is what the police testified to. And you said that's not relevant to this case. And if they disagree with that, that's what the appeals court said. That was your ruling.
But I would agree that's the ruling, but yes. And the basic content of why Mr. Green would be important to the defense, yes.
All right, thanks, Anything else from the defense?
No further proof from Mr. Springer, Your Honor.
Okay.
Judge, I'll go ahead and call Rob McKinney first.
Mr. McKinney, can I get you to raise your right hand, please, sir? Solemnly swear upon the never truth, the whole truth, and nothing but the truth, so help me God.
Is that a
Yes, ma'am.
You may.
Mr. McKinney, believe we met on this case 2.5 years ago. Is that correct?
I couldn't testify to that, but it seems like it's going on a long time.
It's been a while, but I don't have many questions, but of course you've sat in and you've listened today. Is there anything, let me start with this. Is there anything in this case that you felt like you did not understand at the time you tried it?
I wish Mark Creo might have been more honest about what really happened, because today was the first time that I heard that Mr. Coley was the one that might have shot the gun first in self-defense after, and I can't remember his name, but it was Lucky's Car Sales on Dickerson Road. If that was the truth, that might have changed the whole complexion of the case. And again, I apologize, I can't remember his name, but I went out to Lucky's Car Sales.
Mr. Malecki.
Yes. And that might have changed the whole complexion of the case if I'd known that fact, or if that fact was true.
And once again, you were in here. Is it true that the state offered 30 years to serve towards the trial time?
Now, I can't remember that. It was a standard Rob McGuire offer on a first-degree murder. Mr. McGuire had a standard deal that he would offer people 40 years at 85% out of range pursuant to Hicks.
Okay.
That is what his normal offer was on first-degree murder cases. And I can't remember what the back and forth is. And if I'd have known about that Mr. Coley, it was really the true shooter, I might have gone to Mr. McGuire and said, and made a proffer with Mr. Springer to testify against Mr. Coley. So that would have opened up a whole gambit of alternative defenses.
And to get into the case itself, you did bring up that Ms. Lawson had represented both Ms. Reese and Mr. Springer. Is that correct?
Yes.
And what was the reason for that?
I thought that was an inherent conflict, that then they cut a deal with the thing that should be post-convicted is the way that plea bargains are done on district attorney's offices here, that there's no disclosure about what the true deal is and what happened. So Ms. Reese testified against Mark Creo, as well as, and I can't remember his name, Iffy. And miraculously, the day after he testified, his case was dismissed right across that hall, even though they make they say that there's no deals cut, but within 48 to 72 hours, there's a deal cut.
And you actually questioned several witnesses in this case over future deals. Is that correct?
Yes.
I mean, even though you didn't know it, you said, you know there's one coming. Is that correct?
That is the biggest sham criminal offense.
I understand that.
And I apologize for being on the soapbox here.
I work in Wilson County, so likewise, Mr. McGuire, and I want to lay the foundation, so I apologize, I don't want to lead. So Mr. McGuire, from this case, did not put certain links in a chain of custody for the DNA on the stereo. You objected to that being brought into evidence. Is that correct?
Yes, that was my whole defense, was for the exclusion of that. My recollection was they only had the initial technician that drew took the sample off the stereo or receiver or whatever it was, because inside the store he would take parts out of certain cars and put it up there and sell parts. In fact, that's why Mark Creo and Mr. Coley went. He would sell drive-out tags to people that didn't have tags. So whatever the drive-out tag, he'd add $50 or whatever it is so you could drive a valid car. So my point was, in all due respect to Judge Fishman, I thought it was wrong. I think it was 2 links in the chain. They only testified, it's been 10 years ago, they only had the original receiving clerk who did it, the crime tech, and then the DNA expert. So there's 2 check.
And so, and correct the statement, it was your strategy to block the state from bringing those pieces of the chain, therefore blocking the evidence.
Yes.
Okay. And that didn't work, but that was your goal.
That was my goal.
And was there any proof that you were aware, besides Mr. Coley, Mr. Springer, of an alternate suspect other than Mr. Green?
That was the only alternate suspect we had, and he had died by the time I got the case, and there was MAPCO video footage, and I tried to get that in, but there was no interview during my representation of this person. There was evidence that he had been there earlier. He was an alternative suspect. The police even got I think it was a MAPCO right next to Lucky's auto sale, and it showed his car was there. But by the time this case had got to trial or I got involved, he had passed away. So I tried to do my best I could with what I had to get in evidence, or at least, get some sort of flair into the jury that there was somebody else there.
And to be fair, you tried to get it in, and Judge Fishburne said no.
He did not.
Okay. And
I agree with Mr. Russ that I didn't make an offer of proof on that.
Okay. Judge, I think with the issues they've raised, the state has no further questions for Mr.
And where was this video? What was the business location?
It was right next door to Lucky's. It was Lucky's car auto sales on Davidson Road.
Right. What was the business next to it at the video?
I think it was a MAPCO judge.
All right.
Okay, Mr. McKinney, I'll try not to be too repetitive, but I do need to make sure I check certain boxes, okay? You heard Mr. Springer's description of the communication between the two of y'all prior to trial. Is that pretty accurate in your recollection of seeing him?
That is completely wrong.
Okay.
On one occasion that I went to see Mr. Springer, he refused to come out. And I gave Mr. Harris a memo because I came back and wrote an internal memo that I went to jail. Mr. Springer refused to see me, and I wrote an internal memo to show that. I think I brought a couple copies today, but I think I left it upstairs in my binder for a case.
I think the state provided me with a copy, but
okay.
So he said you maybe came 3 times or something like that to the CJC to see him, or wherever he was housed.
I don't have a recollection. The only thing, the vivid memory that I do have is I saw him on the day before trial Sunday for a couple of hours, and I just want to make sure he got a shave, make sure he had a haircut, because I remember it because he was in the special medical needs unit, right? And I went over specifically that there was a high likelihood that he would run into the people that were going to talk to him or testify against him, that they would have him in different holding cells. And I said, please, Mark Creo, you will see them. Don't say anything, because I was worried about there being a potential of the interaction between people who are going to testify him and Mark Creo. And then when I got here at 7:30 to make sure his clothes were, the first words out of his mouth was, Rob, I effed up. And then that's when led to a big ordeal about the threat of a life of a witness. And Mr. McGuire got a jury charge, not only to the flight instruction, but also to threatening a witness during the middle of the trial.
Okay. That being said, leading up to everything for trial and whatnot, I mean, he says you provided him all the discovery that you had. I'm assuming that's accurate.
Yes.
Did the state make their file?
It's been my practice. If I get a piece of paper on a case, it goes out in the mail the next day to the client.
Okay. And did the state make this an open file matter that you were able to see everything they had?
I don't think so.
Okay.
I don't think at the time the DA's office did an open file discovery.
But everything that you did have, Mr. Springer had?
Yes.
There were some video clips that you're talking about from the MAPCO and perhaps some other things that were not, that were digital rather than printed. Did he ever view those that you're aware
I
of?
don't think he ever viewed that. So I was going back on the files. I've now digitalized all my files. I knew I had 2 investigators. I don't know if they went over that or not. So I don't even see her full report, but I know that Ms. Cassett filed an affidavit, and I had Mr. Wells, so I don't know. I didn't see it when I was scanning through all the PDFs. I didn't see a full report, but I know that they were both involved at some point in time.
Okay. I want to ask you a little bit about the plea negotiations that Mr. Springer described. You said that Mr. McGuire had made a 40-year offer that you do recall, and if I understood you correctly, a 30-year offer that Mr. Springer is describing. You don't have a specific recollection of him.
I don't have anything, but I would. If he had got down to the, it's hard to sign someone up 40 years at 85%, especially at the young age of Mark Creo. But when you get down to 30, I would have conveyed any offer because I have an ethical duty to convey any offer whatsoever, and I'd do that.
Well, I'm just saying you didn't have a recollection. He says that you did convey the offer in his mind.
My recollection was that it was contingent on Mr. Coley, and he was not receptive to any offer. So that's my recollection, and I think he was might have been the sticking block.
Do you recall, obviously, you both agree that Mr. Springer rejected the 40-year offer. Do you ever remember either at that point or later Mr. Springer talking to you about a lower counter offer that you could take back to the state?
I would have done any offer that he authorized me to do.
But you don't have specifically recall.
Here today, it triggered my mind, and I think Mr. Coley was the stumbling block.
Okay.
And it was and any offer would have made me joint. Because most DAs, they're not going to give a offer unless it's contingent on both sides because they don't want to try one case and not all of them.
Right. You mentioned just a second ago that when your primary goals or defenses was to try to have the DNA evidence excluded in order to minimize the exposure, but that wouldn't have changed these witness statements about what Mr. Springer supposedly essentially confessed to. Is that right?
I can't remember about those statements because he made the most damaging statement was when he fled to Cookville, and there was recorded some statements coming back from Cookville.
Okay.
And I will say that it was the weakest evidence for the state was and again, my recollection was the indictment was the gun was the thing that was stolen. The only evidence it had was his son said he always kept a gun, and the gun wasn't there when they did an inventory of the house, of the shop.
And that was the item that substantiated the robbery.
I think that again, it's since March of 2011 since I've tried this case.
Sure, but again, as the
that's
state,
my recollection. There was something that was because his son testified because he was the first witness. He advised. Mr. McGuire was saying he likes to put the body, there was a real live person at first. He wants to show the picture of the decedent at first and then get some sympathy going, and then he claimed that.
Mr. Springer mentioned that you'd sent him a letter relating to a possible severance of offenses based on, for example, the blood evidence that Mr. Coley, damaging pieces of evidence that were specific to Mr. Coley, but still by, the transitive property would have hurt Mr. Springer.
Well, that's why I hear his testimony, because when I was seeing the PTFs, I saw some sort of severance that I did. I don't know if I filed it or not. So I tried to look through the court file to see if I found one, because I would always file a severance if I could.
Okay. So you looked it over, but you didn't think there was merit to it?
Well, I think it would be hard, because, under common scheme and plan, I think their plan was, hey, we're going to go buy a drive-out tag, and then while we're there to drive-out tag, we're going to take his money. So I don't know if it would have been good or not. I personally like to go to trial by myself. I don't like to go with other lawyers.
Well, and as far as the DNA and evidence, that would not have really been relevant in the trial against Mr. Springer by himself. Is that right?
Right. Okay. But Mr. Springer and Mr. Coley were together. They were together at the house over in East Nashville, and they were together in Cookville, and they were together when they were arrested.
As far as the information about Mr. Green, you discussed that on your direct testimony. So I guess in a nutshell, you would have liked to have presented him as an alternate suspect to the jury, but you got shut down.
Not liked. Like would not be the right word.
Needed to.
Wanted.
Yeah.
Needed.
Okay.
Desired.
As far as these different strategies that you had, how much discussion did you have with Mr. Springer, and how well do you think he understood what you were trying to do?
I like Mercury a lot. And I think about him to this day. I wish I was a better lawyer to get him to tell me what really happened.
The chain of custody issue, you litigated that as much as you thought you could?
Yes.
Okay. And that was also on appeal?
I waited till I didn't think Mr. McGuire knew really he was a chain of custody guy, because chain of custody goes mostly like in DUI cases, blood,
right,
things like that. So I think I thought he took it for granted, because when we were up here at the bench conference, I think he was worried for a second, and I was hoping he was worried.
Regarding Ms. Reese, not just the chain of custody as far as the blood evidence, but the other items that she produced to the police. This was sort of a blanket thing. You were trying to have all of those items excluded for lack of a chain of custody, not simply
yes.
The court found it to be adequate documentation. And you mentioned about Ms. Reese's relationship with Ms. Lawson, and let me ask you this. For what it's worth, I agree with your opinion about the state proceeding the way they do. Did she expect to get anything in exchange for her testimony, rather than had she been guaranteed anything?
Well, under the 16 rules of impeachment, motivation is one of the most personal. What's their motivation to testify? And motivation is, I hope to get the deal. I hope to get out of jail free card from Monopoly. So under the 16 rules of impeachment, that I like to focus on motivation. Why are they telling their story?
Right, but did you ask that from Ms. Reese? I mean, I'm aware that you asked her, have you been promised anything for your testimony by the state? And the answer was no, whether it was no or not. But did you ask her, did she expect to get anything from the state that had not yet been promised?
I don't remember if I asked that, but I know that Judge Fishburne precludes me from asking the range of punishment of the case of the charges of what they're facing on. Because he will not let me, with all due respect to Judge Fishburne.
Judge Fishburne. Just me now.
What? Sir?
Not just me.
I know, but that's a fact that when I first started practicing law, you could board out the jury on the range of punishment. Now we can't tell them that, hey, they're looking at 51 years and that's why they're telling them so-and-so.
Well,
and 51 years in jail is a motivation to tell something.
We could discuss lines of cross-examination that might get you to where you want to be, but anyway.
I'm gonna get my this is my therapy right now.
Well, yeah. Anyway, I'll leave that for where it is.
The legislature was here.
As far as Mr. Green goes, again, various things were excluded, but how far down the road did you ask essentially of the detectives, was he a suspect at some point?
I think I did, and I think that's when the objections started rolling in.
Okay.
And that's still well, I don't want to get into that either.
You have 1 second, Judge.
Judge, I apologize for my opinions.
Your opinions are always of interest.
Judge, those are our questions.
And who was it that you were not allowed to develop as a suspect?
It was Mr. Green.
Ron Green.
Green?
Yeah, I think it was
Yes,
Green. I think he was a former employee or something with Mr. With Lucky.
That's correct, Your Honor.
All right, anything else?
No, Your Honor.
May I be excused, Judge?
You may.
Thank you.
Division 2's waiting your presence.
Judge Escobar.
Raise your hand, be sworn, please. You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Good morning, and I've tried to decide before I got up here if I'm supposed to call you Judge or Miss Escobar, so if I may switch in between as we go.
Miss Escobar is fine, thank you.
Let's start. You've read these petitions, is that correct?
Yes, sir.
And let's start with the not severing. Tell me what your thoughts were before this trial started.
Well, can I make a general statement?
Sure, I'm fine with that if everyone else is.
So back in 2011, I tried this case, and I decided to leave the practice of law, I think honestly because of this case. And so for 3 years, I went off to do other things, and I gave my file, I believe, to Mr. Eason, Richard Eason, who then passed away. And so I am unfortunately without my file, and all the trials I had that year that we had this trial, I have those files. I took pride in keeping my files and writing notes and writing why I did things. And unfortunately, this is the first time I'm getting post-convicted and I have no file. So what I have done is I requested my billing from the AOC. I got the records from the jail. I put together emails that I had been emailing Mr. Coley's sister to try to recreate this.
Okay.
So I just wanted to give that background.
And I may, let's go ahead and proceed as we are. I may ask you brought that with you, is that correct?
Yes, sir.
And I may let Mr. Kelly see it, and I may ask to make that an exhibit to your testimony. That's your paperwork, but Mr. Kelly, I'm sure will want to review that before we continue that process, but I may just do that just based on the fact that this is your paperwork that you did on this case. But let's start with, let me start here. You had an investigator on this case, is that correct?
Correct. His name was Ed Mason, and he in fact went to see the client 3 times in jail.
Okay.
And he and I went to the scenes. We went to the boarding house. He interviewed different witnesses, and he's the one who actually discovered that all these potential witnesses somehow were going to get a deal. Because we figured out that all these people had cases in different courts, and all of a sudden Rob McGuire was the DA in different divisions, which we found very interesting. And so we followed up with that.
Okay. And you guys questioned each witness about deals or future deals. Is that correct?
Correct.
Either between you or Mr. McKinney?
Yes.
One or the other?
And that, another thing I wanted to bring up is Mr. McKinney had a woman named Carrie Cersei working with him at the time. And Miss Cersei and I worked a lot together in this case, trying to prepare this case and trying to talk about strategies.
And is it fair to say that you and Mr. McKinney worked this case to a certain extent together for a defense?
Along with Miss Cersei and the investigators.
And is it fair to say that part of that defense was going and trying to pin this on Mr. Green?
From what I can remember, yes.
Okay. And of course, Mr. Green's testimony wasn't allowed, and let me ask you this, were you also involved in the decision-making to try to keep out the DNA evidence on the stereo that was against your client?
From what I can recall, and I apologize, from what I can recall, yes.
And it's fair to say that some arguments were made by Mr. McKinney and some arguments were made by you.
And then when he would make them, I know I would join in, and vice versa.
And did you try to sever Mr. Coley towards the end of this trial?
Yes.
Okay.
Yes.
And did that fail?
Yes.
Okay. And you did not try to sever Mr. Coley before this trial?
I cannot recall why or if I discussed it with him. Honestly, I don't recall, but at the end of the day, I did not.
Okay. Was it yours or Mr. McKinney's decision to waive closing?
Well, it was, okay, so back in these days, in 2011, Rob McGuire was, I think, the lead prosecutor here, and he was doing a lot of homicides. And he was kind of known for these flashy second closings where, you know, the first DA would do their closing, it'd be kind of and then he would just come up with these PowerPoints and just demolish the defense. And so we had talked about waiving, what if, it was Mr. McKinney's idea, what if we didn't do a second closing? And that decision was not final until the very end. And I remember sitting in the lockup over there talking to the gentleman, deciding what to do. And knowing me, I would have prepared a closing argument because I prepared, even though it doesn't look like I do today. I would have prepared every question. I would have prepared every cross-examination question, every opening, every closing. So I would have had one in case, but it was kind of a game time decision at the very end.
Okay. And that may be about all I have in a second, but and let me ask you this, and I think Mr. Coley actually answered this, but I'm going to ask you anyways. Was there ever any discussion between you and Mr. Coley about a potential self-defense claim?
No.
Okay.
That I can recall. But can I say something?
Yes, go ahead. There you go. Mr. Kelly says go ahead, so I'm fine with it.
So just for the record, when I looked at the jail visits, I went to see Mr. Coley 13 times, and plus all the court dates, plus I kept in communication with his sister constantly. And what struck me is that every time I'd go visit him, his big obsession was whether or not we could get his bond reduced. And so it was very hard for me to talk to him about things. So much so that I did hire Dr. Brown's husband to evaluate him to see if there was some competency issue or some maybe learning difference, because, you know, I don't know if it was an immaturity or just inability to kind of accept what was happening. So it was very hard for me to get the message across. So I just wanted to put that out. Now, at one point, Rob McGuire did offer him, and I found this in an email, to, if Mr. Coley had testified against Mr. Springer, he would have, you know, severed him and would have given him a deal. I don't recall whether a number was given. I approached Mr. Coley. I really asked him to consider it. I found an email where I told his sister about it. The sister was talking to him about almost begging him to do this. But he, out of loyalty to his friends, would not do it.
Okay. Judge, I think that's all I have. I am going to ask to make the paperwork an exhibit, but I know Mr. Kelly may want to review that before that happens, but I would ask once he gets a chance to make that paperwork, just because I believe it is, I think it is emails with family members, and I believe it is billing and everything like that.
Yes, and I do have, does that have the receipt of where I sold, or I sent him the discovery? One day I went to the property room, took pictures of everything, and then came back and showed him pictures of all the property. You know, just as Mr. McKinney said, I really cared for Mr. Coley. It broke my heart he was in this situation. So much so that I finished with criminal law for a while. But anyway.
And Judge, let me say this, that is paperwork to show her work in this case. I think it would be relevant.
Sure.
Thank you, Ms. Escobar. And I'll go with Ms. Escobar today, as we have been up to this point. And I appreciate your testimony about the file. You know, it's certainly difficult to prepare for one of these things without having your file to lean back on, so we understand that. And I kind of want to hit on some of the things that we had talked about a little bit earlier about this DNA evidence. Now, at the time that the DNA evidence, you know, I mean, this is 2011. It's pretty well established at that point, right? Did you believe that you had the ability to get the court to pay for an expert to kind of analyze this DNA evidence and maybe testify on Mr. Coley's behalf?
You know, I got experts, you know, an investigator and somebody to evaluate him, so I probably could have gotten money for that.
Okay. And in terms of getting an expert to look at the DNA, did you think that that was not something that was necessary in this case? Was the goal to exclude the DNA evidence if possible through this chain of custody thing that emerged later?
I honestly don't remember.
Okay.
I mean, I think it was, you know, he was hurt in that shop, you know, but I honestly don't remember.
Okay. And the reason I ask is because at that point, we don't have an expert. DNA evidence is, unfortunately, in some respects, very, very persuasive to a jury. Would you agree with that?
Yes.
And that DNA evidence was outside of all of this testimony that, you know, that was kind of problematic and that you discovered through your private investigator why it was problematic. That DNA evidence was absolutely the strongest piece of evidence to put Mr. Coley at the scene at that time. You would agree with that?
That and prior to them going there, they had been talking to the people at their boarding house that they were short of money and that they needed a lick. And then obviously afterward, there was the clothes that everybody saw.
Sure. But at the actual crime scene itself,
yes.
That was it.
Yes.
That speck of blood that and do you recall, you know, kind of where it was found and how much there was and anything like that?
I don't.
At that point, if he's at the scene of the crime and he's actually been shot and his blood is at the scene, you said that there wasn't a real discussion about any kind of a self-defense argument. In your discussions with Mr. Coley about, you know, how to go about preparing for this trial, did that ever come up to your recollection?
I don't remember, but what I do remember, and I say this in the nicest way possible, it was very frustrating to try to speak to Mr. Coley because I think he was in so much shock that he was in jail. He was so young that he had a hard time kind of facing reality. But it was hard to speak to him, but I don't recall having that discussion.
In regards to that, the evaluation that you had, was there anything useful that came out of that? Anything that you thought was at least helpful for being able to communicate with Mr. Coley after having gone to the length of having a forensic evaluation?
I don't think there was.
To your recollection, was that kind of hyper focus on bond and getting out? Did that make it very difficult for you to talk to him about his own testimony at the trial? What that would look like if he chose to do that?
Not toward the end, but at the very beginning when we're trying to figure out what to do with this case and the discovery, and it was difficult to get him to focus.
Okay. Did you believe that it was in Mr. Coley's best interest to collaborate with the co-counsel as much as you did?
You know, and we weren't like, we're going to be in this together forever. I mean, we were definitely representing each other's interests, but, you know, interviewing different witnesses and going out to the scene and comparing notes. I mean, we did collaborate in that, but it wasn't like we're all in this together forever, you know?
Right. And the reason I ask is because of things that come up later. As you said on direct, you know, when Mr. McKinney would make a motion, you would join in. Specifically related to the DNA evidence, my understanding was the DNA evidence that Mr. McKinney objected to the state calling a witness that wasn't listed on the indictment, that could come lay the chain of, kind of help with the chain of custody, correct? And then at that point, there was going to be some kind of an argument about whether or not the blood and the DNA evidence was actually going to be able to come in against Mr. Coley. In that moment, you elected not to force the state to to bring in that witness, or to amend the indictment to bring in that witness to do what they would have done to get that DNA evidence in front of a jury. But that was directly against Mr. Coley's kind of self-interest in this case, correct?
I don't remember. Okay. I honestly don't remember any of that discussion.
And let's talk about severance briefly. You said that this is something that you would have filed. You believe you would have argued in a case like this. I believe we heard Mr. McKinney say that he absolutely needed to have a severance. Do you recall ever preparing a brief or filing that motion or anything of that nature?
I don't remember.
Sometimes we use those to negotiate with the state, right? To show the prosecutor, say, I've got a good issue here. We'll waive that if you did that ever happen, as far as your recollection is concerned.
I don't. I'm trying to see if I might have put something in my billing. I just have 12 on December 1st, 2010. The report motion is all it says. So I don't know what that motion was. Let's see. Prepare motion ex parte for psychiatrist. No. I've got a motion in limine for the disclosure of agreements. I don't see anything specifically.
What was it? Was that in court? How did you bill that December 10th?
On December 10th, let me see. Unfortunately.
Or was it December 1st?
Out of court. Oh, wait a minute. Sorry, sir. Yeah, out of court. I don't know.
How much time?
0.3. 0.3 or 0.5, I can't read it.
And that was previous to the trial. That could have been motions in limine or something.
Yeah, it could have been anything.
Okay.
Yeah.
But we never had any actual in-court argument about severance.
Okay.
And your understanding was that Mr. Springer's statements, while Mr. Coley and Mr. Springer both did actually make statements that were introduced through Mr. Maurice Smith, but it was Mr. Springer's statements that were particularly damaging against Mr. Coley. Is that right?
I mean, I don't recall honestly any of this discussion or my thought process or how we prepared for it. I don't.
Do you recall why you would not have objected to Mr. Springer's statements being introduced at a trial in as much as they could only be used against him and not against Mr. Coley in front of the jury.
Are you saying him admitting to shooting? Is that what you're talking about?
Yes.
I would assume that that would make Mr. Springer look more culpable and Mr. Coley be a victim of being shot, I assume. But
Right.
I am so sorry. I don't remember.
Well, we've talked about this, and this is something that is kind of difficult to recreate, and one of the reasons why I don't like transcripts very much. But
And I've not had the benefit of reading the transcript.
and I'll just go. It was page 259, volume 1 of the trial transcript, and this is between Mr. Maurice Smith and Rob McGuire. When Rob McGuire asks him, what did he say in specifically relating to Mr. Springer? And Mr. Smith says, he told me that after William got shot, he shot the guy and watched him take his last breath. Who is he referring to? I mean, in your recollection?
I don't know.
It's kind of difficult to say, right?
Right.
However, in your cross-examination of him, you don't tease that out a little bit. In fact, at all. We don't reference that at all. Did you feel like the jury was interpreting that as a statement directly against Mr. Coley or against Mr. Springer?
I don't recall.
Okay. The incident where Mr. Springer then allegedly made these threats against Miss Reese, you did make your objections at that point in time.
Correct. And
you secured a jury instruction limiting that to only be used against Mr. Springer, correct?
Yes.
And that was the discussion about that was done out of the presence of the jury, correct?
Correct.
Do you recall why you didn't make a contemporaneous objection while the jury was back in when that statement was introduced after the jury out hearing?
I don't recall.
And do you recall objecting to any of the jury instructions themselves?
I don't recall.
Or any reason why you would have to object to the jury instructions? For example, if there was a voluntary manslaughter included as a lesser included offense of felony murder, would you agree that that is not a lesser included offense of felony murder?
Correct.
I'm sorry, I was making a note, I didn't hear the last question.
Would you agree that voluntary manslaughter, if it is included in the jury instructions, is as a lesser included offense of felony murder? Would you agree that it is not a lesser included offense of felony murder?
Correct.
And that a objection to that would be appropriate?
Correct.
Your Honor, one moment. Your Honor, those are our questions.
Okay.
Yeah. Thank you, John.
I answered okay.
Judge, I would ask to make that paperwork exhibit. I'm not sure.
Yes.
Have we made it an exhibit? Not yet. Okay.
No. Well, General Harris, did you file it with your paperwork?
I did not file it.
Okay.
I believe I had
Probably
it,
should,
but
since I'm.
Now, when we're
Yes.
talking about paperwork, just to be clear, we're talking about her AOC.
And then.
AOC and then emails, I believe, to the sister.
Whatever you will reference during your testimony, I guess.
Yeah, the emails I don't have.
Okay, that's fine,
Yeah.
just the AOC stuff. I won't make the emails. She testified to the person.
Any other witnesses?
Not from the state, Judge.
Arguments?
I think it's near the end. I've done it.
It's really down.
Almost in.
You're gonna all go first. Obviously, we've had
Copious amounts of written pleadings. So I'll try to just stress two main points that I think might have been amplified on by the testimony of everybody today. Excuse me. First, regarding the severance issue as it pertains to Mr. Springer, I think Mr. McKinney was clear, one, that he prefers to try cases by themselves, and two, that he thought it would be beneficial in this particular circumstance, and three, essentially he would have if he could have. But I think what he stated was a little bit of the mishmash of rules, the rules of procedure 8 and 14, when he said that, you know, I wouldn't disagree that this is a common plan or scheme potentially, or certainly that these could be joined, but that doesn't mean they can't be severed. And under 14C2A, if the court determines that in order to have a fair determination of the issues, the parties should be severed, like potential evidence that would come in against Mr. Coley that is damaging to Mr. Springer, but really isn't relevant or isn't pertain to him directly, or alternate defenses, as perhaps Mr. Kelly's going to argue, there'd be a brutal issue going the opposite direction for Mr. Coley. But all that being said, I think that Mr. McKinney, having researched, I guess, the way he described it, the possibility of filing a severance, wanting to file a severance, thinking it being beneficial to file a severance, then not doing so, I would say is deficient. And again, I don't know if it's a misunderstanding or just a jumble in his head about why that would not be the case. Again, they could be joined. They have been joined. They probably were properly joined, but they still could be severed.
What would have been the legal basis for Mr. Springer to get a severance?
I would say, Your Honor, again, that it would be something in the nature of alternate defenses, that contrary defenses, I guess, probably the better way for me to state it. You know, the state was able to demonstrate through scientific evidence that Mr. Coley was present. And that's problematic for Mr. Springer, too, since they were supposedly together, but the state can't prove that Mr. Springer was physically there through any kind of physical.
Except indirectly or by implication.
By implication, correct. Now, of course, there's statements that are purportedly made by Mr. Springer, again, I frankly think both of them would have been better off having trials by themselves for various reasons, but I'm not arguing for Mr. Coley. But yes, I think that, yes, by implication, some of the negative evidence that was not directly linked to Mr. Springer still damaged his defense. So that would be the legal basis, that the fair determination of the issues required a severance had Mr. McKinney pursued that. The more central one that I wanted to focus on, which is one of the main issues and probably the only issue that I raise as a fresh issue in my petition, is the issue of the negotiations. You know, Mr. Springer said, I recall getting a 40-year offer and rejecting that offer, and Mr. McKinney thought we should reject that offer. We're on the same page there. And then Mr. Springer says, I recall getting a 30-year offer closer to trial, and I did reject that, but I also made a counteroffer. And I was willing to accept significantly more time than my counteroffer was, up to probably 25 years. And I would have done that in 2010 or whenever the trial was. But I never heard back, or I never heard further from Mr. McKinney. Now, should he have followed that up and asked and said, what happened about my 15-year offer? Did it ever get any better? Did it get any worse? What are we doing here? Absolutely, he should have done that. Obviously, you know,
If I understood the testimony, he said that go back to 15, and then there was never any other discussion whatsoever. He never represented to Mr. McKinney down the road, you know, I'll even take 25, but I'd like to get to 15.
I think that, well, yeah, I think that was the case. I mean, I think that's what he stated, although that combined with what he said, I'm not sure whether he told Mr. McKinney that, or that was what's going on in his head.
That's what I'm trying to verify.
Yeah.
I understood that was what was going on in his head. That had he come back and they said, okay, they'll take 25, he would have taken it because it would have been within
the range. Yes. I think that Mr. McKinney might have known that, but I'm not sure. Okay. But again, and Mr. McKinney, unfortunately, and I don't blame him, here we are 10 years or 12 years later, doesn't enlighten us very much, other than to say that essentially he agrees with Mr. Springer in so much as if Mr. Springer had had a counter offer, he would have conveyed it. And if he gotten a secondary offer from the state, he would have conveyed that to Mr. Springer. So presuming he did his job like he says that he would have, which I don't doubt, then what Mr. Springer recalls did happen. Why it was not followed up any further, I don't know. Mr. Springer's recollection was that his impression was these were not contingent offers, and he could have accepted his time regardless of Mr. Coley's decision. Mr. McKinney's recollection is more based on his experience with Mr. McGuire in general, and district attorneys in general, not wanting to try. I mean, if you try two people or one, it doesn't matter. It's the same amount of work, which I understand, but that doesn't mean it was the case here, and he had no specific recollection of that. So my point is that if Mr. Springer's at 15 and the state's at 30, that's a deal that can get done and probably should have gotten done. And I don't know why. Sure, Mr. Springer should have followed up, but also Mr. McKinney should have at least told him they said no about your 15-year offer or anything else. And no one seems to remember very much after that. So other than Mr. Springer said, the next thing I knew, we were having trial the next day. So I would say that that also is something that some light has been shed on. The rest of the arguments, I think, are made pretty adequately in our pleadings. And of course, the court heard all the testimony, so I'll just let that be. But I will say that I think there was a deficient representation, and obviously, particularly with the plea negotiations, that was prejudicial to Mr. Springer.
All right, thank you.
Your Honor, you want to hear General Harris respond to that?
And the other one?
However y'all want to do
it. It doesn't matter. As for Mr. Springer, Judge, I did file a response a few weeks back, knowing now there was going to be no more filings. I'm just going to go through them briefly. There was some discussion over Mr. McKinney bringing up the fact that Ms. Reese and Mr. Springer were represented by the same, I think it was Joan Lawson. He said it, and I think it was accurate, a strategic decision. You show that there's maybe some interminglings. You show there's a little muddiness. That's a classic defense. There was no objection. I'm just reading through the responses, reading through the amended petition. There was no objection to some hearsay done by Tabitha Reese. That was based on a note left on a door saying that Mr. Springer and Mr. Coley were behind on rent. The note was testified to. It was also testified, though, by Mr. Maurice Smith, who was another tenant in this home, that he told them that they were looking for money. So that was the evidence was coming out regardless. Miss Tabitha Reese, there was some discussion about her not being, this was one of the tenants, not being talked about future deals. However, Miss Lawson, her attorney, was talked to about that. So I would say the job was done there as well. There's been no proof today of an alternate suspect. They talked about it, but there's been no proof put on other than this Mr. Green that was denied at trial by you based on the relevance and confirmed and affirmed by the appeals court. There's been no proof of an alternative suspect put forward today. Failing to communicate with the petitioner. Mr. McKinney says he met with him. Mr. Springer says there's nothing that he didn't know that he wished he would have known. This offer and counteroffer, the offer was 30 years. And I understand what the defense attorney is saying, 30 and 15, the deal should get done. That's a big difference in years, 30 and 15. We're talking half of what the state's offer was. There's no proof. Number one, I don't think Mr. McKinney knows if there was ever a 15-year said, but he said I would have sent it to him, as I do every time. The offer was 30 years, and as Mr. Springer said, he wouldn't have taken that before this trial. He never would have taken the 30-year offer that the state had offered him, and that was the only offer on the table. As to Mr. Springer's argument of severance, I don't know legally that there is one. I've heard nothing here today to suggest that Mr. Springer could have severed this case. The only statements that were put into the record other than I will go back into the facts a little bit. As for Mr. Springer's case, the testimony, and this is going to be my version, and they may dispute some of this, but as the appeal court says, there was discussion of a robbery between Mr. Springer and Mr. Coley at their home. The people who listened to that were Miss Reese and Mr. Smith, and then a Mr. Nwagwe was the one who provided a gun, and he testified to that. There was a discussion of this. They leave the home. They come back. Mr. Coley is shot. So far, all of that testimony is coming in on Mr. Springer. Mr. Coley is shot. Mr. Springer has a new gun with him along with his other gun, and he tells somebody that it's the victim's gun. And he says, Mr. Coley was wrestling him, and I shot the victim and watched him die. Now, I understand that there's some dispute over how that can be interpreted. That's the way the appeals court interpreted it. They then fled. They were arrested in Putnam County. before they fled Davidson County, Mr. Coley called in a robbery himself, saying he was robbed by 3 individuals and was shot, received medical treatment, and then Mr. Coley and Mr. Springer fled Davidson County, found in Putnam County. When they were arrested, there was a discussion in the back of the patrol car about these events, basically saying, if they ask you, say the victim was saying all this racist stuff, and then they said, maybe let's not talk about it. So all of those facts were coming in. I would argue, and Mr. Coley's DNA was left at the scene. I think all of that proof would come in for Mr. Springer. They were together, they were together, they were together. I don't think there's anything that would have happened at trial that would not have happened for Mr. Springer. So I would say there was no reason for him to ever get a severance in this. As to the chain of custody regarding the DNA on the stereo, there's no proof today that there was anything wrong with the handling of the DNA at that time. There's no expert here today to say that something was done inappropriate. So I believe that issue is waived today. We can't go back and say there may be a mistake, let's turn this over. There has to be ineffectiveness plus prejudice. There's no proof that anything happened. There's no proof that anything was wrong. So I believe that the chain of custody was Mr. McKinney's shot at trying to keep it out. He knew Mr. McGuire did not put on every link in the chain in his witness list. He knew that he could argue for no surprise witnesses. So he took a shot to try to keep the DNA out. It didn't work. The court let it in. It was a strategy and it failed. So the state would argue that at this point, there's no reason to believe that DNA wasn't accurate. There's no reason to believe that there's some issue with it today, and therefore that issue would also not stand. So we'd ask that this one also not be overturned.
All right.
As General Harris probably knows, we don't get money to get an expert at this stage of the game. So whether or not we're able to produce an expert who can come in here and say, you know what, there's problems with that DNA, we can't do that. We can't provide that to the court. However, the argument on Mr. Coley's behalf is that trial counsel didn't do that either. Trial counsel did not attempt to get a DNA expert, although,
Well, let me ask you on that.
Yes.
What would you have hoped? Let's say because you got the benefit of looking back 10, 11, 12 years.
Yes, we do.
What would you have been hoping to get out of that expert? That it wasn't your client's blood? Because there's no question he was shot.
Your Honor, yes.
At the scene, so you would reasonably expect that some of his blood would be there.
Your Honor, and that's his blood was at the scene and he was shot. That's a pretty good circumstantial piece of evidence that he was shot at the scene, okay? The DNA expert, if we have money to hire one, can come in and tell me, hey, look, this is what I can tell a jury. This is what I can talk about collections. This is what I can talk about, how important it is not to contaminate something. This is what I can do. Because in a certain respect,
So the expert would not have been to challenge the lab results of what was shown, but that there was possible problems in getting it to and tested by the lab.
Yeah, potentially.
The chain of custody.
Correct. And do we know how that would have turned out? We don't. We don't, because we didn't go that route. And conversely, Your Honor, if the DNA expert is not going to say anything helpful to us at all, now I know that. I know that beyond a shadow of a doubt. I know that, and I'm going to talk to my client about, look, they put you at the scene. You got a gunshot in your arm. The only defense that we have is that you acted in self-defense in this situation and that you were protecting yourself. And that would have led to a much different trial. In fact, probably 2 different trials. If Mr. Coley is testifying in his own defense related to a self-defense issue. And that's one way to kind of force the severance that both parties, I think, looked upon as a favorable thing. We don't know anything about the severance issue because Ms. Escobar did not file a motion to sever her client. I think that the argument is stronger for Mr. Coley about severing him from Mr. Springer, just because of the statements, Your Honor, not just prior to trial, but during the trial. And there was, and the Court of Criminal Appeals said that the objection to this testimony from Ms. Reese about Mr. Springer's threat to her should have been made contemporaneously in front of the jury and not allow the jury to just sit there with that evidence for the rest of the trial and wait until the jury instructions, at which time they're getting bombarded with a ton of information, right? And they're hearing all types of stuff. And if a jury had heard, look, you can't use this against Mr. Coley at the time that they hear it, that may have helped in this situation. I mean, we're a little frustrated in our efforts here because of Ms. Escobar's and completely candid and very welcome testimony about her loss of the file. Today is the first time I ever heard that he had been evaluated. I mean, wow. But that said, Your Honor, I think that when we break down kind of where the ineffective assistance of counsel comes in here, we heard a little bit of it, and it sounded as though, and I believe Ms. Escobar, when she said she was kind of developing her own theories, but in reality, we followed Mr. McKinney's moves almost every step of the way, including the waiving of the closing argument, including removing our objection to this DNA evidence that did come in that was incredibly damaging to Mr. Coley. And Your Honor, that, in our view, the cumulative effect of all those errors is what led to essentially a situation where Mr. Coley, who, I mean, on the stand today, he doesn't have a great understanding of the law. Great. We don't expect these guys to definitely come in here and do that and wow us like they're Alan Dershowitz. But this was Mr. Coley's first trial. He had no idea how these things went. He didn't know he had to argue that before trial. He thought it might come out of trial. He did not have the basis of knowledge. Your Honor, and in talking about Bruton and severance issues there, I would simply also reference in the motion for new trial and the appeals there that, Bruton is certainly controlling on this issue, but Crawford versus Washington, I think, even gives broader protections to defendants. And I believe that was not argued on his behalf in those appeals situations. We don't have anybody here to argue about the appeals. That's a purely technical issue. I think that the other issues are much stronger for us. And Your Honor, for those reasons and all of the petitions that we have filed up until this point, we'd ask that you grant our petition here today. I will say that to the court that I did receive a final set of amendments to this post-conviction petition. This came in the mail yesterday. I would ask leave to make a late filing of these amendments after we are finished.
Another petition?
No, Your Honor, it's simply in addition to what we've already provided to the court. And this is from Mr. Coley, who sent this to my office, and I received it this morning.
Have you seen it?
I have not seen it. And likewise, I had not seen Ms. Escobar's.
Have you seen it today?
I haven't seen it today. I haven't read it, haven't seen it.
Some of them are duplicative, Your Honor, but in the issue of
Is there anything new in them?
Your Honor, there are some nuanced arguments here for Mr. Coley that I would like to have in part of his record if this case goes up on appeal.
I'll accept it from a written argument perspective. I'm not going to accept it as evidence, any type of evidence.
Not as evidence, Your Honor, just as argument.
And not as new issues. But give some additional impetus to whatever he's already raised. But I mean, there's no new issues that were raised today as a result of that, is it?
As a result of this, no, Your Honor, like I said, these are more kind of deeper arguments about things that we've raised already, specifically in regards to the Crawford versus Washington issue, Your Honor, and discussing the jury instructions that we did have testimony about today in front of this court. And Your Honor, there was also some more stuff about waiving the closing argument, things of that nature. Thank you.
I guess so. And Judge, I'll be brief, and I do understand Mr. Kelly's view that, and situation that he has no funds to hire an expert. But let me say this: I think it's inappropriate to overturn a conviction and call an attorney ineffective on a guess, on a hunch. And so I don't think that is also the appropriate means to say, well, we could have done it and it could have shown something, so therefore let's call it ineffective. I don't think that's the answer. I think you have to be ineffective and show prejudice. There's no prejudice shown over this DNA expert. But Mr. Coley also testified she knew everything about the case that he was aware of. And another thing, this DNA at the scene, Mr. Kelly says the only logical defense is self-defense. Mr. Coley never said there was a self-defense. He on the stand today said, we never talked about self-defense. We never discussed it. There was no self-defense. That wasn't part of this case. There was never a discussion with his attorney of any hint that this was a self-defense case. So we can't guess at defenses or pull them out of the sky. There has to be some proof of it. There's no proof this was a self-defense case. We've gone over communication. She knew everything. Severance, he may have had a good reason to sever. There were statements came in by Mr. Springer talking about shooting, having in his possession a gun of the victim. However, those statements were interpreted by the appeals court that Mr. Springer shot the victim and had in his possession the gun of the victim, not Mr. Coley. So those statements could have come in either way, but even so, they don't kill Mr. Coley's defense. Depending on how this case plays out, and once again, and I'll back up again a little bit, without those statements, his DNA is still at the scene. He still talked about a robbery before he goes. He still calls in a phony own robbery of him being the victim. He still runs to Putnam County, and he's still talking in the back of a patrol car with Mr. Springer. Still not great odds for Mr. Coley, but the statements that came in put Mr. Springer as the shooter. That was obviously a chance to show Mr. Coley was not the shooter. As to the threats, the appeals court addressed this as well, and the court can read that, but there was a limiting instruction done at the end, not at the time, but the job was done, and the appeals court in part 7 addresses that and says the court corrected it. As to the objection of the DNA, same logic. It's a strategy. They tried to keep it out because they knew if it came in, they knew how damaging it was. So they tried to keep it out. It failed, but they tried. And all we can do, all the defense attorney can do as the state, is do their best to manipulate the evidence, to show the evidence as it is, or try to keep it out. They tried to keep it out. It didn't work. It came in, and the state had their proof.
Well, just for clarification, I mean, there was no constitutional basis to keep it out. I mean, it was seized properly. It was part of the homicide investigation. The only strategic move they can make would be on the chain of custody, as I understand it.
That's correct.
I mean, I haven't reviewed this case in 10 years, but I mean,
the argument was chain of custody.
The approach that they took was the valid, viable approach, is what your argument is.
That's correct. And the court said at the time that this was taken that there's been no proof that anything is out of the ordinary right now, so therefore I'm letting it in, I think is what the court said. And there was a couple of changes. The intake person at the TBI was not on the witness list, nor was the person I think who sent it from Metro to TBI. So,
but the reports, the chain of custody report showed everybody's name.
So we could have gotten them. General McGuire offered, they refused. Court said, done enough, let it in. So that was it failed, but there was an attempt.
And were those reports made exhibits?
I don't know.
I would assume they were.
The TBI agent testified, I think, to how she obtained it, but now whether or not there was an exhibit made of that, I'm not sure. As to waiving closing, once again, Mr. McKinney, I'm not going to re-go over what he said. That was the reason why Mr. McGuire would manipulate what the defense attorney said, would turn it on its head. That's why they chose to do it. That was a clear strategic reason. Self-defense, there's been no proof, still not proof. Alternative suspect, no proof. They talk about the appellate improperly briefing, not using Crawford. Bruton was used. We all know that chain of cases that exist. I would say that still properly done. Let's see. The last one, Judge, and I'll say this, and Mr. Kelly did not address it, but he talked about the trial court did not give the instruction, and trial counsel did not request the instruction for the natural and probable consequence doctrine jury instruction. The state attached the case to its filings. Basically, this is a felony murder. The state's arguing that that instruction doesn't apply to felony murders. We attached a case to that effect. But I will save the case and let the court read that at its pleasure. But Judge, Mr. Coley, ultimately, and Mr. Kelly's right, Judge Escobar's memory is not strong in this case. It is a dozen years old at this point whenever she was appointed. That's one good reason. However, you know, she still got to testify. She still has to get up here and talk about what she remembers, and she did that. But ultimately, the state sees the biggest issue in her representation as whether or not there should have been a severance. That's, to me, the largest issue. There's reasons not to do that, but regardless, even if let's go down the road, and I'm not saying she is, let's say that it was ineffective. I don't believe it. It's my argument is that it's not, but let's say that it's ineffective. Mr. Coley is still talking about a robbery, DNA still at the scene, still flees, still calls in a phony robbery, still arrested, still talks in the back of the patrol car. There's no sign that it would have prejudiced or changed the verdict of where he is.
No. Anything else? I'll let y'all know. It'll take a little more time to go back to review.
Please take as much time as you want.
Yeah, we can set it for the end of July for status. I'll get it out before then, but
that's fine with me.
A lot of this was just starting to piece back together as I was hearing the testimony.
Yes, sir. And let me ask you this: do I return?
No, you should have the order before then.
Yes, sir.
And if you have it, if you're still on return, it'll come out.
And if the court needs, if you need a further hearing, I'm happy to come back. Mr. Garrett's always good to contact.
Yeah, I don't think we will. No, Mark, is that the most recent petition?
You're here for.
I'm here for Paul. No, that would just be.
Yes, I'm here for that.
Not as good.
I'm hoping one's fixing to strike somewhere, instead of here in this office, we're gonna get police.
Oh.
You got another set tomorrow. Cause they tell me, like,
Yeah. Yes.
okay. Makes sense.
Come on.
Well, I was just wondering because.
We got 13. It's in my list.
But I can understand why it's the multiple, I don't know why.
Like Joe Force?
If they haven't been able to. That's gonna be the same.
I was like, man.
Free Joe, thug life.
Yeah. Oh, well, yeah.
Sister, baby mama sister.
I gotta get this officer out of here, we'll take please, and then we'll do the next one. We're just running behind because. Of course. Michael, I need, Carter, and I need Hyde at the table.
Okay, his uncle is
Please.
disabled, and so he can't do anything. All right.
See ya. And Sean, she's in the waiting room. No, Hyde sits down, Harvard stands here for the next. What, and Harvard go down? You can't go anywhere yet, there's nobody in this courtroom, Jay don't go in, go to the bathroom, and Steve don't know where they are.
Are we doing?
No, he's.
That doesn't help you today either, yet. You need it. No, good.
much less taking accountability for leaving that person there. Is that
Yes.
correct? Okay. All right, I believe those are all my questions. Thank you.
Detective Sean McKay from Mr. Hyde. Good afternoon.
Good afternoon, sir.
Detective, does the video you reviewed from the scene, it doesn't put Mr. Hyde anywhere near the robbery or the parking lot or anything like this at the time of the...
No, sir, it does not.
Okay. And the witnesses that were present for the robbery and shootout, none of them would put Mr. Hyde at the scene, correct?
No, sir, they did not.
And I guess to keep from dwelling on the point too much, through your investigation, would you say that you don't think he was there when the shooting occurred?
No, sir, I don't believe he was.
Okay. Through reviewing the text messages between Mr. Hyde and co-defendant, how far back were you able to review their messages?
I don't recall the time on that.
Well, were you limited in your search warrant to just the day of, or could you go several months back?
The text messages that we got were from the actual device, not from like phone records. They were actually from the device itself.
Okay. Well, do you recall if you reviewed all the text messages between the two?
I'm sure at some point I did, but I don't recall.
Did there appear to be a lengthy history of text between the two, or was it kind of recent?
I got the impression that they were acquaintances more than long-term friends, I guess to say.
Okay, so not a lengthy history, not a lot of.
Not that I'm aware of.
You wouldn't characterize the conversation as jovial friends or people checking in on one another.
No, sir, I didn't.
And in the text messages between the two of them, is there a clear plan in development, or is it one party's kind of fishing for information out of the other one?
It seems that Mr. Jones is wanting Mr. Hyde to give him information about what's going on, where he's at, locations, and things of that nature.
Okay. So, and Detective, you and I have kind of spitballed about how this whole event at the Elk Lodge was organized and basically what it was. But essentially, I guess it was maybe like a 3 day long hip hop performance rented out, I guess, at this venue where it was going on for several days.
Yeah, I believe so. I guess they rented the Elks Lodge, and that's where they had their venue at.
Okay. Well, when you say they, who is they?
Oh, I was referring to what I found in my investigations was Mr. Shields, the victim, his girlfriend, Mr. Gadlin, and Mr. Hyde were all part of. I don't know who else was part of that venue that set up and helped do that deal, but I know those individuals were part of it.
Okay, so if I can kind of help here, you'd have, I guess, 2 or 3 promoters of an event. Yet, well, what was your understanding of Mr. Hyde's involvement there?
That he was like Mr. Gadlin and helping set up and helping set up and help run the venue for Mr. Shields.
Okay, and was Mr. Hyde kind of like a DJ?
That was my understanding, yes.
Okay, so he was part of setting up this event, and you had Mr. Shields and then Mr. Gaglin, and so we don't really know who rented out the lodge, but we know that there was a 3 or 4 day concert series. Would that be correct?
Yeah, I think it was 2 or 3 days.
2 or 3 days.
Yeah,
it was more than that.
The NFL draft that was here.
So you had a large group of people coming in and out. We don't know who was there each night.
No, sir.
But we know there were several people promoting this thing on social media.
Yes, sir.
Do you recall if there was a cover charge posted, or did anybody?
I can't recall. There was like little, I guess, I don't want to call them posters, but when you think of like movie posters.
Little flyers you see on social media.
Right, there were on social media that were promoting the event, and I'm sure it probably said something on there, I just don't recall.
Do you know, I know one person could have multiple social media accounts, but do you know if there was more than, I guess, Mr. Gaglin, Mr. Hyde, and Mr. Shields promoting it? Were there other people promoting this event?
I don't, I can't.
Okay. So we do know there's at least 3 or 4 people involved in the setting up, organizing, and performance.
Yes, sir.
Okay. You mentioned somebody had posted something about a bag of money before the robbery occurred?
Yes, sir.
Have you been able to determine who was posting on social media, hey, down here at the Elk Lodge, we've got a bag of cash?
Well, the photos I got came from the phone that we recovered from the scene, and 100% sure, no, I'm not sure, but it appears to me that I thought it was Mr. Hyde's arm that was in the money bag.
Okay. So was this published to all of Instagram or Facebook or somewhere?
That I cannot answer. I got it off of the phone, but that's what it looked like it was taken from, was an Instagram or something of that nature.
Okay, so you weren't able to find on someone's Instagram or Facebook photo?
No, I don't believe I did, no, sir.
Out on the website?
No, this was from that device we found at the scene.
Okay. And as a promoter of the event, he would, I guess, well, let's get to the bag of money, whether it's $10,000 or $15,000. Do we have any idea how those proceeds came to be in the bag?
I don't. There was things that said that they had gone and gotten money for a bank for, I guess, from strip clubs for, I guess, the strippers that were at the Elk Lodge. Was that all that was in the bag? I don't know. I don't.
So there's probably the bills that they had in there might have been for making change for the 30 strippers. Or
I'm guessing, but yeah, I mean, that
could be from anything. You could have a bag at where you have, what did you say, 30 strippers?
I think that's what the posting.
There's a whole lot of strippers at this place, I guess.
Well, yeah.
Okay.
Seems like a lot.
Right. And about how big was this venue?
We walked around inside, but I really don't recall. I want to say it's a fairly good sized building, but it's not huge.
Okay.
So, it would have been really crowded with
30 strippers and
people to go along with that.
And that's not even including the musicians and other.
That's correct. Yes.
Talent. Okay. So are there any discussions between Mr. Hyde and his co-defendant about money specifically, or is there a mention of a bag and 30 strippers?
I don't know if the 30 strippers was mentioned in there. There was some photos, like I said, of the bag with money in it. Some discussions about the bag there, and I would have to read back through the text messages to actually tell you what they said for sure, but there was some about the truck, some about where they were, things of that nature.
Okay. Were there any prints of Mr. Hyde found in the car? In the white, I believe, Hyundai?
Not that I'm aware of, no, sir.
Okay. And I guess based on your research and investigation thus far, there's no connection to Mr. Hyde in that car?
No, sir.
And I guess everything, I mean, there's still more to be done, but of all of this event, the connections that we know of between Mr. Hyde and his co-defendant are that they were both promoters or involved in we know Mr. Hyde and Mr. Shields were promoters or involved in the promotion of this event. And do you think the co-defendant was also a promoter in the event?
I don't believe so, no, sir.
Okay, so the only connections between Mr. Hyde and Mr. Shields and this co-defendant are somebody was plugging or fishing for kind of information on the event, information on who was kind of heading up the event. Mr. Hyde gave, hey, here's where you can find him. And there was basically text messages suggesting that they had been in communication. And then Mr. Hyde's gone from the event.
Yes, sir.
No other questions.
Whose phone was it that was located in the?
The defendant is James Jones. His phone was found at the scene. It was a iPhone 10, which was a fairly new phone at that point, I think.
No, thank you.
That's all for the state.
All right, Ken.
Sure, I have Mr. Hyde's mother on Zoom, I hope, I think.
Well, we'll just have to see how that plays out. Did they fix the equipment?
She's connected. She's connected audio, but I've asked her to do a video. So hopefully she will. You may want to tell her in that microphone so she can hear you.
Ms. Hyde, can you hear me all right? Let's see. I hear something. Is she connected to us now?
She's still connected, but she just muted her phone and she had to turn on the video. There's her video, her audio is on, her video
Hello.
is on.
Hello. Ms. Hyde, good afternoon. Can you hear me all right?
Hello?
Can you see me?
No, not yet.
Yes, sir. Hey, I'm connected. Hold on. I don't see me doing.
Can you hear us, Ms. Hyde?
She's disconnected by mistake. She'll call right back.
That's definitely not her. Yeah, that's her. Can you hear me all right, Ms. Hyde?
Yes, sir, I can hear you.
Okay, thank you, Ms. Hyde. Ms. Hyde, we're going to put you under oath real quick. If you could raise your, well, I'll let the court do that part.
Ms. Hyde, if you'll raise your right hand, please, I'll swear you in. You solemnly swear from the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right.
Okay, thank you, Ms. Hyde. And you spell your last name Hyde?
Yes, sir.
And for the court reporter, how do you spell your first name, ma'am?
Shandrita.
Shandrita?
Yes, sir.
Thank you. Okay. And Ms. Hyde, what is your relationship to Mr. Devontae Hyde?
I'm his mother.
Okay. Ms. Hyde, you know why we're here today to discuss a bond reduction. Ms. Hyde, if the court were to lower Mr. Hyde's bond to an amount that you could make, where would he reside?
With me.
Okay, he would reside with you. And where do you live, Ms. Hyde?
3112 Brookdale Avenue. I mean, I said
Okay.
Brookdale Avenue, Brookdale Lane, apartment B.
Okay. Okay, and that's here in Davidson County?
Yes.
Correct. Okay. Well, I see
Yes,
I see you work at St. Thomas. Is that correct?
Yes, sir.
Okay. So are you employed full time?
Yes, sir.
Okay. And about how many days a week do you work?
I work 5 days, try to work 6, because I put in overtime at least once each pay period.
Okay. So
That's what you said?
okay, could you repeat? I believe you said something about overtime.
I work 5 days a week, but I usually put in overtime each pay period.
Okay, so I believe she said she works 5 days a week, but she usually puts in overtime. Okay.
Yes.
So Ms. Hyde, if you were to be able to make Mr. Hyde's bond and he were living with you, who else resides at your home?
No one. My daughter,
Nobody.
she's in college in California.
Your daughter's going. Where is she going to college in California?
Stanford.
She's going to Stanford. Okay. And
Okay.
are you helping her with any assistance?
No, she has a full ride, so she's covered.
Okay, so she's on a full ride at Stanford. So your finances working there at St. Thomas would be going to support, I guess, your own housing, and I guess you would also be helping Mr. Devontae Hyde along, correct?
Yes, sir.
Okay, so would you be able to, working 5 days a week, would you be able to, or do you have family members that could assist in Mr. Hyde making it to court dates?
I can assist with that.
Okay, you would make sure he would be here. Okay, okay.
'Cause I can work. I'm sorry.
No, you go ahead.
I was saying, because the days you go to court, I can schedule my days off and just work another day, so I could go with him.
So you can rotate your schedule and make sure he's here when he needs to be. And you in fact were here from about 9:30 this morning to about 11, correct?
Yeah, because I had to be at work at 11:30.
So you can work your schedule around getting here.
Yes.
So I give the judge the impression that he's just been sitting around doing nothing while you support him. Prior to him coming into custody, what did Mr. Hyde do for a living?
Well, like he was like far as he DJ'd a little bit, but he would go down to the temporary service where they do pay you like day to day.
Okay. And about how often would he go there?
Yeah.
I'm sorry?
At least 3 to 4 times. At least 3 to 4 times a week.
3 or 4 times a week, he would show up to the industrial day labor to work. And what other employment?
Get up there.
What other employment did he have?
Before then he was working at some type of factory. I don't know, remember the name of it. But I don't know why he, then he was working at FedEx before, like as not as a deliverer, help them deliver the person on the truck. He was a helper.
Okay. So has he consistently worked since he's been an adult?
Yeah, he's worked, yeah.
Okay, let's talk about his DJing job. Was he a DJ prior to becoming incarcerated?
Yeah.
Okay,
And he
and
was
what,
a DJ promoter.
a DJ and promoter? And about how long had he been doing this?
He been doing that since he like got out of high school, like in college. When he first started going to college, he started promoting and DJ parties.
Okay, and do you know about like what he was doing? Did he have equipment and a computer and setup like that, or was he just using other people's equipment? What was he doing?
He had a computer and one of them little boards. I don't know exactly what they called. One of them little
Some
board
sort of
things.
mixing board?
I'm not familiar without, but yeah.
Okay, so he had equipment. And do you know about how often he would work these events?
I know he was DJing at Tarbouche. It's on, I forget what street it's on, it's so close to them, but he was DJing at Tarbouche on like, I think Thursdays and Saturdays, and then like it was a special party, like when it was certain, like college parties and stuff like that, he would do that stuff like that.
Okay, so is this, you said Tarbouche, is this the hookah bar restaurant place?
Yeah.
So a couple of times a week, he would DJ and do events there?
Yes, and then he would just do like college parties, or if somebody was throwing something, they asked him, he would do that.
So did you say he'd do college parties and if someone hired him? So he had a side gig where he's a DJ, and he had some set schedule events, but then people would call him and hire him to do other shows.
Yes, sir.
Okay. So about how long do you know that he had been engaged in that line of work?
Like I said, he's been doing that since like when he first started college.
Okay, so this is a money-making side gig that he has. Okay, so I guess to your recollection, I know he has had a DUI. Did he have much trouble has he been in any real trouble?
No.
Okay, and you feel like you would be willing to put your hard-earned dollar on the line for him making it back to court and not getting in any trouble between now and the time his case is resolved?
Yes, sir, I will. That's my son, yeah.
Okay, now let's talk about some funding. You had some documentation for me this morning. We were talking about your income. About how much do you make a year, ma'am?
Oh, I would say, let me think for it. I got a calculator in my head. Should I make almost $2,000 a month? It's like $24,000.
$24,000. Okay, and as you stand here today, about how much do you have in your bank account that you could contribute toward your son's bond?
I have $1,900.
You have $1,900. Now, you have been working with some family members. I believe you had, was it your aunt that was here this morning?
Yes, my Aunt Rovina.
Okay. And does she live here in Nashville?
Yes, sir.
Okay. And I believe she's retired, correct?
Yes, she is.
And I believe she's married to somebody that works over at Vanderbilt.
We lost her.
Just the video.
Sorry, my phone rang. I'm sorry.
That's all right.
She married to Dwayne Daniels.
Okay. And this aunt, she told you she could, not including her 401k, but how much cash did she have that she could give toward making this bond?
I think she said $2,500.
$2,500? Okay. Now, she could get into her 401k if possible, correct?
Yes.
And she's willing to do that. We're not wanting to have to dip into her 401k, but she could do that if need be, correct?
Yes, she's willing to.
Okay. If the court were to reduce the bond a significant portion to where you could bond your son out, if the court put strict curfew guidelines or work hour guidelines, would you have any problem making sure your son's at home to abide by those times and being where he needs to be?
Might want to ask that again.
I'm sorry, I guess
If the judge were to put some strict guidelines on curfew or only leaving the house to go to work or things like that, would there be any problem with you enforcing those and keeping your son at home and being where he needs to be?
no, sir. No, sir.
Okay. Well, thank you, Ms. Hyde. I don't have any more questions at the moment. The state or the court might.
Okay.
Good afternoon, ma'am.
Hey, how you doing today?
I'm good. I just have a few questions to ask for you. I'm Brian Ewald with the District Attorney's Office, okay?
Yes, sir.
I wanted to ask you, Mr. Hyde, how old is he?
He's 29.
Okay. And did he have any trouble in juvenile, when he was a juvenile? Like, did he have to go to juvenile court for any reason?
No.
Okay. And Mr. McKinney touched on it, that your son does not have much of a criminal history, but he does have a conviction for DUI. Is that correct?
Yes, sir.
Okay. And were you aware that he had previously been convicted of a misdemeanor possession of a weapon, a handgun?
No.
No? Okay. That would have been back in 2012. And were you aware that on two different occasions, in 2013 and in 2017, that he failed to appear for court?
No, sir. Because usually when he has to go to court, we make sure he goes to court.
Okay. Let me ask you another question. Now, Mr. Hyde is charged in two pending cases. Obviously, one, the big one, is he's charged with a first-degree murder case, but he's also charged with a misdemeanor possession of drug paraphernalia. Are you aware of that?
Yes, sir.
Okay. That case was based on a search warrant that was executed on Brickdale Lane, where Mr. Hyde lived with Edward Hyde. Is that another son?
Yes.
Okay, so that's...
No.
No?
It's a cousin.
Who is Edward Hyde?
That's a cousin. He's a cousin.
Thank you, ma'am. All right, and how long did your son and Mr. Edward Hyde live together on Brickdale Lane?
Devontae's been there for a while. Edward just was there.
Okay, but that would not be where he'd be going back to live if he were released on bond, is that right?
Yes. He will be going there, but there's no one there.
Okay, is Brickdale Lane your home?
Yes.
Okay, all right. So that search warrant that I referred to, that was a search of your house, correct?
Yes.
Okay. And stemming from that, again, Mr. Hyde is only charged with possession of drug paraphernalia, but the cousin, Edward Hyde, is charged with more extensive drug and there might have been guns recovered as well. Hang on.
And something he had in his backpack.
A large quantity of marijuana, digital scales, a loaded handgun, various bullets, gun magazines, cash, all that was found during that search of your home, correct?
In his backpack.
Were you present when that happened?
When they had came, I was asleep. I had just woke up when they came.
Is Edward Hyde on bond right now?
No. I'm not for sure. I think so. I'm not for sure.
If he is, he's not living with you.
Oh, no.
Okay. And he
There's no
wouldn't
one
live
in
with
my
you.
house but me.
No one but you. Okay. All right. And for the record, that search warrant was executed on August 6th of 2020?
Yes. August, what is this? Yeah, 6, 7, one of them.
Okay.
It was basically something was in the backyard or something.
All right, thank you, ma'am.
All right, anything else? Good. Did your, how far did, your son go to school? Ms. Hyde?
I couldn't hear you.
What, how far did your son go in school?
Uh-huh.
Did your son graduate from high school?
He graduated.
From high school?
Yes, he graduated. He did some college.
Did he go to college?
Yes. Yes, TSU, yes.
How long was he a student at TSU?
For maybe like 3 years.
Why did he stop?
He didn't have enough credits, and I think he ended up having to pay. So yeah, he said he's gonna go back, but.
Was he living with you all this time?
He's always lived with me. He's gonna stay with females before, but he always have a place in my house.
He also what?
I mean, he done stay with females, like girlfriends before, but he always have a place in my house.
But where was his primary residence? Girlfriends or your place?
My house. He always say his primary residence is my house.
All right, thank you.
All right.
Thank you, Ms. Hyde.
Anything else?
All right, I can briefly call Mr. Hyde if the court or state are interested in more specifics about where he would be working.
As long as it's not in promotions.
And we discussed that.
Or DJing.
While he is presumed innocent, and while he did have a good side gig, a good robust side gig, I understand the court's worry and there could be criminal activity tied to some of these events. I don't know. But we do know he had a legit business, but he's going to just do the day labor. He's not going back into promoting until this is resolved.
Your Honor, the state would submit that obviously Mr. Jones is the shooter in this case, and that's what the proof supports. The state is in no way attempting to implicate that Mr. Hyde pulled the trigger in this case. However, circumstantially and based on criminal responsibility for the conduct of another, it's the state's theory that Mr. Hyde set up this robbery, which obviously resulted in Mr. Shields' death. So, very serious case, very serious implications. We'll defer to the court on ultimate decision.
Anything else?
Briefly, Your Honor. Your Honor, Mr. Hyde does have long and lengthy and numerous ties to the community. He has the capabilities of working. He has the capabilities physically, mentally,
the skill set to do a lot. He could easily go finish his college education and do just about anything. He doesn't have a criminal record that I think would be disturbing, at least to me.
I don't find anything disturbing about his criminal record.
So what we have, Your Honor, is a young man who made it pretty far in school, is healthy, doesn't have a mental health history, doesn't have a history of being violent. He does have a history of working several jobs. The proof before the court, if everything is true, he tipped someone off to where a bag of money would be in an event that stands to reason he probably could have profited from the contents of that, whatever were in that bag, if it were split up. I'm just now kind of catching on to what the detective threw out about he might have himself been worried that he was going to be robbed. I'm going to have to dig into that, but we do know that it's not clear that there was a robbery set up. It is clear that there is a discussion about a bag. There's also a discussion about 30 strippers in a club. So marijuana comes in a bag, ecstasy comes in a bag, cocaine comes in a bag. I'm not using drug dealing as an excuse, but that reference could be to a lot of things besides a bag of cash. But if he did have something to do with setting this up, that's going to work itself out. But we do know if everything as alleged is true, he directed somebody toward where the other promoters would be. He wasn't in possession of a firearm at the scene. We don't have anybody saying he was even there. We don't have anything other than he told someone, yeah, I'm here tonight. Yeah, this is where so-and-so parks. We have several family members that work hard that want to assist him in getting out. Right now, his bond on this case is $250,000. The bond on the drug charge that General Ewald has mentioned a couple times is $2,500. I believe he has probably served enough time to have flattened that sentence, and I'll discuss that with General Ewald just briefly. But his mother has a couple $1,000s. His aunt that I spoke with, I think his mother said the aunt had about $1,900. In my discussions with the aunt, I thought she said she could probably round up $3,000 or $4,000 in addition, pretty quick. So I would say a $40,000 to $50,000 bond, Your Honor, would be what this family could make to ensure that he's going to make it to court without a 65-year-old having to drain her retirement fund to give it to a bonding company. So he has substantial ties to the community. He knows that it's his mama or his great aunt that are losing their shirt if he doesn't show up in court. I think the likelihood of conviction here is very iffy. That's an easy thing to say for a defense attorney, and you'd probably expect me to say it, but there are a lot of question marks in this case. Mr. Hyde's role here is still questionable. So I would ask the court to reduce the bond about $40,000 to $50,000. There's a lot of work to be done here. I don't think there's any question that he's going to make it to court. He has family ties, family support, and I think probably $40,000 is sufficient.
Set the bond at $50,000. It'll be on GPS. He can leave from 6:30 in the morning till 6 in the morning because of day labor. You got to get there pretty early. To 5 in the afternoon. Otherwise, he'll be at home with mama 7 days a week. He doesn't need to be going anywhere on Saturday and Sunday unless his mother's going to drag him to church. And if that's so, he can come back and we'll see what that situation is.
Thank you.
You know, get an address.
Stevens White.
Mr. Stevens? Mr. White?
What's her address? His mother's address?
Got it. 3112 Brickdale Lane.
Stevens, you sit in this first chair, and you sit in the third chair.
Brickdale Lane, Davidson, C 37207.
And the judge will go through a series of questions, make sure you answer yes or no in the majority, okay? Listen this out loud. Let me get you two to stand and raise your right hand to be sworn in.
Solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help me God.
I do. You have to be seated.
All right, gentlemen, I have before me petition as enter pleas of guilty in your cases. I need to ask you some questions regarding your decision to enter the pleas of guilty, as well as some questions regarding the rights that you have as a criminal defendant. Since we're doing this in a group format, what I will do is ask the question. I will then identify each of you individually, at which time you can give me your answer to the question. Most of the questions will require to give a yes or no answer. It's very important that you verbalize the word yes or no. Cannot accept any ahas, nodding, or shaking of your head. I need a clear record of what your response is. Also, if I ask you a question that you do not understand, you need to let me know that. I'll rephrase the question until such time as we have a clear understanding with each other. And finally, if for any reason you need to speak to your attorney during the course of these proceedings, let me know that. I'll stop the proceedings, give you an opportunity to have those discussions before we proceed any further. Do each of you understand the rules I just went over, Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
You understand that each of you have just taken an oath to tell the truth. And if for any reason you should answer my questions falsely, or any questions asked of you about the district attorney general falsely, while in open court in the presence of your lawyer, you could be subjecting yourself to the possibility of being prosecuted for perjury. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
How far did you go in school, Mr. Stevens?
I finished 12th grade.
You're able to read and write?
Yes, sir.
Mr. White, how far did you go?
11, but I got my GED.
You're able to read and write?
Yes, sir.
Are either one of you currently taking any medications, whether they be prescribed, over the counter, or otherwise? Mr. Stevens?
No, sir.
Mr. White?
Yes, sir.
What kind of medication?
Abilify.
Neither of you have been consumed any type of alcoholic beverage or other intoxicant within the last 24 hours. Mr. Stevens?
No, sir.
Mr. White?
No, sir.
Neither of you ever been diagnosed with suffering from any type of mental illness or other mental disorder. Mr. Stevens?
I had a tumor when I was a baby.
Pardon?
I had a tumor when I was a baby.
Okay, is that tumor self-resolved? Do you have any issues
I had
with
surgery. Had surgery.
that? And any effects as a result of that surgery?
Nah, I don't know too much about it. It was, when I was little. My mom don't talk too much about it.
Mr. White?
Manic depression.
Okay. The medication that you're taking for that, does it work?
Yes, sir.
Feel like your mood's stable here today?
Yes, sir.
Know why you're here and what you're doing?
I'm here for a plea deal.
All right. Is there any reason that either one of you can think of that you would not be able to fully understand and appreciate what it is you're doing here today? Mr. Stevens?
No, sir.
Mr. White?
No, sir.
Each of you has submitted to the court a petition to enter a plea of guilty in case which appears to have been signed by you. Did you in fact sign the petition, Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Before signing the petition, did you have an opportunity to either read the petition in its entirety or have your attorney read it to you? Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Go ahead and get Mr. White to sign the petition since he's here in the courtroom. During the time that you were reading the petition or your attorney was reading it to you, to the extent that you had any questions, did your attorney satisfactorily answer those questions, Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Do each of you believe you fully and completely understand the contents of the petition as you sit here today? Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Mr. White, since you're here in court, we need to go ahead and get you to sign your petition. Although you're just now signing it yourself, you did go over all of that long before.
With my lawyer.
Okay. All right, Mr. Stevens, you're charging 2020-C-1755 with aggravated assault during a 15-year sentence in the state penitentiary, fine of up to $10,000, range applicable to you being 3 to 6 years. Is that your understanding, sir, of what you're charged with and the possible punishment related to that offense?
Yes, sir.
You understand what it takes under the law to be found guilty of that particular charge In other words, what the state would have to show you did at the trial of the case in order for a jury to convict.
Yes, sir.
I understand you can be pleaded guilty to reckless aggravated assault. You can be sentenced to 2 years in range, 1 offender, 30%, which will be suspended. You'll be on supervised probation for 2 years under the provisions of 4035-313, special conditions of which you will submit to an alcohol drug assessment. Following treatment recommendations arising from that assessment, you'll be subject to random drug screens. You must complete an 8-hour anger management program. Is that your understanding, sir, of what you're pleading to, as well as the actual punishment being imposed?
Yes, sir.
Do you have any questions at all regarding what you're charged with, the possible punishment related to that offense, or what you're pleading to, and the actual punishment being imposed?
No, sir.
Mr. White, you're charged with 2020 C-1804 with 2 counts of domestic aggravated assault, each carrying sentences of 3 to 15 years of state penitentiary and fines of up to $10,000. Range applicable to you being 6 to 10 years, or is it 10 to 15?
10 to 15, 6 to 10 as far as.
10 to 15 years on each offense if convicted. Is that the understanding, sir, of what you're charged with and the possible punishment related to those offenses?
Yes, sir.
You understand that each of those are separate offenses and are convicted of both of the trial case to be punished separately for each conviction?
Yes, sir.
You understand what it takes under the law to be found guilty of those particular charges? In other words, what the state would have to show you did at the trial of the case in order for a jury to convict.
Yes, sir.
Understand you can be pleading count 1 to aggravated assault. You can be sentenced to 8 years of range 2 multiple offender at 35%, which should be served under the provisions of the community corrections program. Special condition which you continue to comply with all the requirements put forth by your mental. Has he already been screened? I mean, he said he hadn't died.
Yeah, I already like.
He received services. I mean, I think they wanted to do a screen for community corrections, but we anticipate that he's already.
You'll have an updated mental health evaluation.
Okay.
You'll follow any and all recommendations arising from that updated evaluation. You will attend and complete a 26-week batteries intervention program, and you'll be subject to frequent drug screens.
Yes, sir.
Is that your understanding, sir, of what you're pleading to, as well as the actual punishment being imposed?
Yes, sir.
Do you have any questions at all regarding what you're charged with, the possible punishment related to those offenses, or what you're pleading to, and the actual punishment being imposed?
No, sir.
Before deciding to enter these pleas of guilty, did each of you have an opportunity to discuss in detail with your attorney the facts and circumstances leading up to your arrest? Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
During those discussions, did your attorney explain to you the law that applies to your case, as well as the evidence the state says that they have against you? Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Also, during those discussions, did your attorney explain to you any defenses that you might have to these charges? In other words, what strategies you would use in an effort to overcome or negate the evidence the state says that they have against you? Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
During the course of those discussions, to the extent that you had any questions, did your attorney satisfactorily answer your questions, Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Do either one of you have any complaints whatsoever regarding the representation your lawyer has provided you in your case? Mr. Stevens?
No, sir.
Mr. White?
No, sir.
All right, gentlemen, I need to ask you some questions regarding the rights that you have as a criminal defendant. Please listen closely to my questions. Make sure you understand what your rights are, because as a condition of the plea agreement, you will be required to waive or give them up. Therefore, it's important that you understand them so you make an intelligent decision as to whether or not you in fact wish to waive them. First of all, do you understand you have a right to persist in your plea of not guilty, demand a trial by jury, and require the state to prove your guilt beyond a reasonable doubt? Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
You understand that if you were to demand a trial by jury, that you'd be entitled to a public and speedy trial by jury. In other words, I'd have to set these matters for trial as quickly as possible in order for a jury to render a verdict in your cases one way or the other. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Also understand that if you were to demand a trial by jury, that it would in fact be the state's responsibility to prove your guilt beyond a reasonable doubt. You'd have no responsibility to establish your innocence because under the law you're presumed to be innocent. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Further understanding, if you were to demand trial by jury, that you be entitled to a fair and impartial trial by a jury of your peers made up of citizens of Davidson County. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Do you understand that at the trial of the case, you would have the right through your attorney to confront and cross-examine the state's witnesses who would appear in open court to testify against you? This is right here in this witness chair. The state's attorney would ask questions. Then your attorney would have the right to ask questions, challenging the witness's credibility, challenging their memory of the events that led to your arrest, anything that would be relevant, material, and beneficial to your side of the case. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Also understand that you would have the right to use the subpoena powers of the court to require witnesses to come in and testify on your behalf if you had any such witnesses. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Further understanding that in the trial of the case, you would have the right to testify if you chose to. However, no one can force you to testify against yourself. And if you chose not to testify, then I would tell the jury they could not use your silence to infer any guilt on your part. I would remind the jury that you presumed innocent. You do not have to prove your innocence. The state has to prove you guilty, and therefore you don't have to do anything in the trial. And if you chose not to testify, I'd make it clear to the jury that they could not consider that during their deliberations. For example, they couldn't speculate that by not testifying, you must be trying to hide something and therefore guilty. It would be a matter they could not discuss or use against you for any reason whatsoever. You understand that, Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Do you understand that if you were found guilty at that trial, you have the right to have the jury set any fine in excess of $50 for the court to set your punishment in a separate sentencing hearing? Furthermore, you have the right to appeal both your conviction and your punishment to a higher court. For that court to review what occurred at your trial and sentencing hearing to ensure that you received a fair trial and sentencing hearing. And if that court did not think that you had received a fair trial and or sentencing hearing, they would grant you the appropriate relief, including the possibility of a new trial. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
And finally, do each of you understand that throughout all the proceedings I just gone over, you have the right to an attorney? And if you could not afford an attorney, I would appoint one to represent you, and that would include your appeal in the event that you are found guilty at the trial. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Do either of you have any questions at all regarding the rights that you have as a criminal defendant? Mr. Stevens?
No, sir.
Mr. White?
No, sir.
Do each of you understand that if I accept your pleas of guilty here today, that this will end your case in the court once and for all? There will be no further plea discussions, jury trial, sentencing hearing, appeals, or anything else. This will be your final appearance in court. Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
In your case, Mr. Stevens, you understand that if I accept your plea of guilty here today, that you'll have a permanent criminal conviction on your record. And in the event you are convicted, Mr. White, you understand if I accept your plea of guilty here today, that you'll have a permanent criminal conviction on your record. And in the event you're convicted of a crime after today, the fact that you pled guilty here today could be used against you to increase the punishment on any future conviction. In other words, the more crimes you commit, the worse the punishment becomes. Do you understand that?
Yes, sir.
In your case, Mr. Stevens, due to the nature of the plea agreement that's been reached on your behalf, if you successfully complete the terms and conditions of probation, upon successful completion of that probation, you can come back to court, ask the case against you be dismissed and your record expunged, in which case you would not have a permanent criminal conviction on your record. However, if for some reason you should violate the terms and conditions of your probation, one of the consequences of that violation is that you lose the benefit of this type of probation. Upon that occurring, you too would have a permanent criminal conviction on your record, and the increased punishment provisions under the law would then apply equally to you. Do you understand that?
Yes, sir.
Also, hopefully you're entering pleas of guilty to domestic violence related offenses. In your case, Mr. White, you understand that you've been forever prohibited from owning, possessing, or otherwise exercising control over a firearm.
Yes,
Should you ever be found guilty under federal law of violating that statute, you could spend up to 10 years in the federal penitentiary for which there is no parole.
Yes, sir.
Is there a home, a gun in your home?
No, sir.
And do you own a gun?
No, sir.
Mr. Stevens, in your case, so long as you are on probation, you as well cannot own or possess or otherwise exercise control over a firearm because you are subject to the same federal statute that Mr. White is. However, if upon successful completion of probation, that requirement will cease to exist, and you would then be allowed to, carry a gun under the circumstances the law allows. You understand that?
Yes, sir.
But right now, do you have a firearm in the house where you reside?
No, sir.
Do you own one and give it to somebody else or anything of that nature?
No, sir.
Does anyone threaten you with anything or promise you anything in order to get you to enter these pleas, Mr. White?
No, sir.
Mr. Stevens?
No, sir.
Raise your hand and these pleas are guilty because you are guilty, Mr. Stevens?
Yes, sir.
Mr. White?
Yes, sir.
Stevens, madam? Oh, wait a minute, for the attorneys, do you believe your clients understand the nature of the charge against them, the law that applies to those charges? Pros and cons of entering plea versus going to trial, that they're entering pleas freely, knowingly, and voluntarily, Mr. Kelly?
Yes, Your Honor.
Mr. Rothbaum?
Yes, Your Honor.
Waive confrontation of witnesses, Mr. Kelly?
We do.
Mr. Rothbaum?
We do as well.
All right.
Your Honor, case 2020 C 1755, State of Tennessee versus Narquan Stevens. State's proof would have been that on August 5th, 2020, officers were dispatched to 2604 Solon Drive near Davidson County, where they spoke with the victim, Quinta Thomas, who was the mother of Mr. Stevens. She stated that she had to do a verbal altercation with Mr. Stevens' girlfriend when she arrived at that location, which is Mr. Stevens' home. Ms. Thomas said she got into her vehicle to leave to avoid further confrontation, and at that time, she observed Mr. Stevens running into the roadway with a handgun in hand and shot at the vehicle multiple times, striking the vehicle at least once. That is state's proof in that case.
You shot at your mother?
Sir, I didn't know that it was my mother. I thought somebody was stealing my car. She used a spare key.
Well, did you hear the facts read about the district attorney general?
Yes, sir.
Are those facts true and correct?
Yes, sir.
And are you gonna waive your rights here today and plead guilty in this case?
Yes, sir.
In 2020-C-1755, are in charge with reckless aggravated assault. How do you plead?
Guilty.
Based on the plea of guilty, I find you guilty. However, I defer entering the judgment of guilt. I do find there's a factual basis to support the plea of guilt. Mr. Coughlin, to enter said plea and that you're doing so freely, knowingly, and voluntarily, and therefore place in effect the previously announced plea. White.
Case 2020 C 1804, State of Tennessee versus Derek White. State's proof would have been that on August 14th, 2020, approximately 7:30 a.m., a domestic disturbance occurred at 1271 Antioch Pike, apartment 316. That's where Mr. White, the victim in this case, resided and were in a relationship at the time. Mr. White wanted keys to the vehicle that he shares with Ms. Smith. She refused to give the keys to him because she needed them to go to work, caused him physical altercation. During this physical altercation, Mr. White pulled out a pocket knife and held it to Ms. Smith's, the victim's throat. Did not cut her with it, but she did sustain scratches and bruises during the altercation. That is the state's proof in that case.
Mr. White, did you hear the facts read by the district attorney general?
Yes, sir.
Those facts true and correct?
Yes, sir.
Are you gonna waive your rights here today and enter plea of guilty in this case?
Yes, sir.
2020-C-1804, we're in charge of aggravated assault, count one, how do you plead?
I plead guilty.
Based upon your plea of guilty, I find you guilty, I find there's a factual basis to support the plea, that you're competent to enter said plea, and that you're doing so freely, knowingly, and voluntarily. I therefore place in effect the previously announced plea. So has Ms. Gallman just gotten so high and mighty, having been named in Forbes magazine or whatever it is, that she just